Namaste and greetings. I, Tripta Behra, researcher at IMPRI, Impact and Policy Research Institute, प्रभाव एवं नीति अनुसंधान संस्थान, नई दिल्ली, extend my warmest welcome to you all to IMPRI Web Policy Learning. We are gathered today for day 2 of a 3-day immersive online legal awareness and certificate training program on women's rights, laws, and policies in India. This training course is organized by IMPRI Gender Impact Studies Center, GISC. This course will be conducted by various expert resource persons comprising academicians, advocates, where women's concerns and issues will specially be addressed and reflected vis-a-vis enforcement of rights, concerned laws, and sectoral policies. The chair for this program is Professor Vibhuti Patel, visiting distinguished professor, IMPRI, and eminent economist and feminist scholar. Our experts for our course are Professor Dr. Saumya Uma, Advocate Sanchita Ain, Professor Vishal Narain, Advocate Dr. Albertina Almeida, Dr. Amar Jesani, Ms. Urvashi Prasad, Advocate Dr. Shalu Nigam, Professor Vijay Lakshmi Nanda, and Dr. Nivedita P. Haran. I welcome all of you to this enlightening deliberation and thank you for being interested and putting your time, energy, and efforts into understanding emerging issues concerning the impacts of policies in promoting gender equality and helping us to bring together the practitioners and participants through this course for impactful policy research and action. We also have shared course outline and reading resources in your email for your kind perusal. Before we start today's session, I would like to remind the housekeeping rules once again. Please join the meeting on time. There will be a Q&A session after each presentation. Kindly share your questions in the Q&A box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise and refrain from making general comments in the question to save time. Now, without further ado, let us start with our program. It is my honor to invite Professor Vibhuti Patel to start the program with her opening remarks and recap of yesterday's deliberation. Over to you, ma'am.
Yesterday's sessions were extremely engaging, enlightening, and also very educative. And they were and we also had an equally enriching discussion, and we got a lot of food for thought because the overarching concern of the women's movement were shared by Professor Saumya Uma in her very first lecture. She started the whole history of social reform movement and how the new laws about age of consent and the opposition against child marriage, criminalization of female infanticide that happened. The first modern school for women in was started by Savitribai Phule and Fatima Sheikh. She talked about that. Women's contribution in the freedom movement, both at a leadership level, in terms of policy making, in terms of creation of a women's role in the planned economy way back in 1935, women's contribution in the discourse on UDHR, Universal Declaration of Human Rights in 1947, and the series of reforms that India had after 1975, which was declared as the International Women's Year, and the role of women's movement, grassroots movement, social movement, the pressure created from bottom, bottom-up approach, and then also then the legal judicial activism and the legal activism that we experienced for nearly 30 years, and formation of women empowerment policy, National Commission for Women, Shram Shakti report, perspective plan for women, and globally CEDAW and Vienna Congress, Women's Rights, Human Rights Convention, platform, Beijing Platform for Action, SDG is Millennium Development Goal, and SDG, that whole journey of last 200 years, she, Professor Saumya Uma, explained in a detail with lots of illustrations and images in her PowerPoint presentation. We also had, and she also talked about essentialist construction of women, which so many mainstream movements had, including the freedom movement, which always saw women as mother and women as citizens or individuals. For that, this feminist in the freedom movement, they had to really struggle. Then second presentation was by Advocate Sanchita Ain. As she's a practicing lawyer, she shared the rights of survivors of sexual violence under criminal law by explaining each and every minutest aspect of both the content, procedural aspect, and the way things need to be, the kind of homework that every survivor needs to do in terms of documentation and all. She demystified all the legal provisions, and also she gave several examples in a very simple, lucid, and most touching was her empathetic manner in which she gave all her presentation, which was also extremely engaging. And she also talked about code of conduct for the police, about which now the state has become more serious after Nirbhaya tragedy. And then we, even both the sessions, Sanchita Ain session and the previous Saumya session, they created massive healthy curiosity among the participants, over 130 participants, and they asked also questions. More than 20 questions were asked, but they could answer 3-4 questions. After that, each and every question was answered individually in the question box. The third presentation by Dr. Professor Vishal Narain, that was a very important, because it examined the political economy aspect of water management, and he talked about his overall focus was on livelihood management and the kind of initiative both state and non-state actors, what kind of work they have done, what kind of gender biases. He started with the basics of what is gender and gender bias, gender-based division of labor, and also gender gap in all the livelihood strategies and the resources and entitlements, and even in the decision-making processes. And he also, all three speakers, one thing good was that they were on the same page so far as sensitivity towards intersectional vulnerability was concerned. And I think that's why we had a very important, very good
you've been...
Yeah. Today we are going to have equally vibrant session with Albertina, pioneer in the struggle against sexual harassment at workplace, right from the 80s. In fact, we learned a lot from the Goa experience. So we are also at the debate on abortion. Currently, we have recent changes in the abortion laws, and plus globally, you know, America has curtailed, so many states in the USA have curtailed abortion rights, which was a long drawn struggle of the women's movement. So and also the question of how the courts are responding to the cases of domestic violence. All three are extremely important issues so far as the women's movement is concerned, and currently also lively debates are going on. So it's going to be a very, very engaging session today also.
Thank you so much, Vibhuti ma'am, for that brief recap. It was wonderful. I would now like to call upon Advocate Dr. Albertina Almeida, lawyer and human rights activist from Goa. Over to you, ma'am.
Thank you, and good evening to you all. In this presentation, I will be speaking. I'm a lawyer by profession, but I also dabble in academics and do some writing, and of course I'm an activist. So you will find different elements of these different parts of me in this presentation, because I do believe that it's important to combine all these various elements when we are talking about engagement with the law. I have just talked to the organizers. I just wanted to have a sense of how many of you have attended a sexual harassment session? And I think they will put that out yes, they put out the poll. So if you can please respond to this poll, so that I just have a sense of how many of you have attended, because this is unlike the other subjects. This is something that is mandated. So by and large, most places have some session or the other. So it's quite possible that you have already attended these sessions, and in which case I would imagine that a few things have already been stated, and I will move from there. So if you can respond to this poll, is it that everyone is responding to the poll? How does it
Yes.
go?
Yes, ma'am. We need to keep it on for about 30 minutes, and then we'll share it.
Yeah. Okay.
Ma'am, meanwhile, you can have your presentation on the screen.
Yeah. Yeah, sure. Yeah. Are you seeing the
Yes.
poll on top of the presentation? That's how I'm seeing it, so I'm not very sure.
Yes, yes, perfect.
Okay.
Anshula, now I think we can end.
Yeah. Sorry. Is it unshared?
Yes,
I have to share it again.
yes.
Oh, sorry.
68%.
Okay. So
2/3.
okay. So not everyone has attended
68%.
some session. Okay. So then that means I will have to say a few basics as well. Okay. So yeah. So the topic here is about understanding and using the law on sexual harassment at the workplace. And if you have been through the readings, one of the readings was the law itself, because it's not stated in very complicated words. The law is quite explicit and clear in that sense, but there's a lot to be read in between the lines of the law. So, and that is what I'd like to focus on, because the law is something that all of you, I presume, can always read. It's a reading that was also shared. I suppose you've read it, even if you've not attended any orientation session on sexual harassment at the workplace. So I would say that this thing is blocking it. Sorry. Can I have this menu on top removed from there, or do I have to do something?
Ma'am, is there any window being popped up?
Yeah, there's a window with like mute, stop video, participants on top.
Oh, ma'am, just ignore it.
Okay, because
Just ignore it. Yeah. That's
so then I'll have to read because my material is. Oh, sorry.
Ma'am, you can see left bottom on the screen.
Yeah.
Left bottom.
Yeah. Oh.
You can share again.
Okay. Sorry. This. Okay.
It's working mode. You have to make it screen.
Yeah, I'll do that. I'll just take this up. Yeah.
Yes.
Okay.
Ma'am, bottom left. Come to the bottom left of the screen. Yeah, bottom left.
Yeah.
Now
Okay.
you can see that is from there you can change. The first two,
Okay, yeah, okay.
Okay, that is the control.
Yeah, but the window of my, where I'm speaking is covering some of the matter from the slide.
Okay, so ma'am, you can come to that ribbon at the end.
The ribbon at the end?
No, not from here. The one which is hindering you. At the top,
Yeah.
The screen share one.
Yes.
And you can come to the the rightest one. Then more options will come.
Yes.
Then there is hide ribbon option.
hide self-view.
Yeah.
Okay.
Now is it?
But the others, I can still see. Okay. You are all still blocking me. Your face, your you know, your screens. Is it? Can you?
Should I do this share, ma'am? Would that be helpful?
Okay. So I'll need to send this across to you then in that case. Okay. Yeah. Sorry. I'll stop it.
Yes.
Okay. I'll just maybe send this across to you.
Mm-hmm.
Sorry. I've sent it to the director IMPRI address.
Okay. Okay, ma'am.
Yes. Yeah. So while the sharing is happening, I can keep talking. So as I said, there has been a historical engagement on this subject, but like the speaker yesterday said, you can't say that a particular case is the beginning, because there are many, there have been many experiences of various women in dealing with sexual harassment at the workplace. I remember in Goa itself, there were cases where people used to go to the labor tribunal and then labor court, and then there they used to say that this issue arose. I didn't go to court. I mean, I didn't go to work because there was this problem, and you know, so I didn't attend, and then I've been accused of not, meaning I've been they've sort of slammed the charge of absenteeism on me. So you know, but at that time there was no framework, you know, because it was like, you look at absenteeism, are you absent or not? So you don't kind of relate it to sexual harassment. So this is where it was felt, you know. So there were these kinds of various experiences, and I'm sure there were similar experiences in other parts of India as well. And it is when perhaps it is when the Bauri Devi case happened, and you know, there was like a kind of a mass collective kind of coming together, that it kind of you know, it kind of blew up. And in that sense, it also resonated for all the various women's groups and individuals who are battling with this issue. So that is my sense of how this issue has come into the thing. But and here I will say that, so some people at that point of time, there was no law, so some people complained and others didn't complain about sexual harassment at the workplace. Now, let me also tell you that at that time, the options, since there was no law, there was no judgment on sexual harassment at the workplace, the option was to complain to the police or to file some long-drawn civil suit for maybe damages or something like that. So it was when Bauri Devi's case came up. So these are some of the, as I said, and as the previous speaker has also said, that that you know, these are not the only cases. These are not the beginning and the end, but these are some of the high profile, if I may use that word, high profile cases. So you have all these various cases, and I will quickly run you through some of the key points that these cases have thrown up. That will be the first part of my my lecture. And after that, I will talk to you about what the law actually contains, and maybe we will also look at some of the limitations of the law. So, so here, if you see, as far as the Bauri Devi case is concerned, one of the first things that shocked everybody is a judgment in the case in which she had complained. So she really didn't get justice from the criminal case as such, because that was the only option she had. In her case, it was gang rape, and the only option that she had was to lodge a complaint at the police station. She went through all the ordeals that everyone then and now still go through with regarding such cases, but eventually she kind of persisted. And I also want to say at this stage that I'm using her name because we have the permission from her to use it. We don't necessarily use the names of the women whose complaints or whose cases we are talking about, but this is because we have her permission. So in Bauri, the outcome of the judgment, the criminal case, the judgment was that, where the judges, these are some of the conversations that happened at that time. So I'm talking about them. So in the judgment, there was this thing that this kind of conclusion that the judges arrived at, that she couldn't have been raped. And they said that upper caste men won't rape a lower caste woman. So, that really shocked a lot of us, I think, and sort of galvanized everybody all over the country. In fact, sometimes you have to turn negatives into positives. So this is how this happened. And what was the case about? Do you all know? Do you all know? Or some of you don't know about this? Okay, I will just say it briefly. So Bauri Devi was employed by a program of the government in Rajasthan to create an awareness on child marriage all over the, going on a door-to-door campaign, so to say. And she was pretty successful in that sense, in terms of creating that awareness and winning people over, which there was a community there, which is a upper caste community, which perceived that as a badge of their honor, that they could get their children married off at a young age. So when they saw that she was convincing people, they did not want to they did not want to give in. They wanted to teach her a lesson. So obviously they planned, and it was a gang rape. So just in order to teach her a lesson, and then followed the whole run of the law. So what you can see here is that, first of all, this is not the traditional workplace, of so can you see the side of this particular the poster, the last one? I don't know if it can be seen by everyone. There are three. You can see the visual of the last one.
Yeah.
Oh, okay. So the first one, as I said, about the judgment. The second is that sexual harassment is an act of power, because very often they say sexual harassment is an act of lust. Poor fellow, he got seduced, or he, that kind of imagery. But here you can see that there wasn't any of this. They were trying to teach her a lesson because she's successful, and she's disrupting their plan to go ahead with their tradition of child marriages. So you can see that sexual harassment is an act of power. This is no better example to explain that sexual harassment is basically an act of power. And then the other point, the third point, that workplace is not necessarily an office or factory. Here is a case. What is the workplace here? You can see that she was going door to door. So like her workplace is going door to door. Her workplace is not an office, not a factory. She's employed by someone, definitely, but she's not her work. The venue of her workplace is not an office or a factory, because the normal presumption is that is the workplace. So this in engaging with this case, the whole meaning of workplace was broadened. Next. So you had another case that was in the news at that time. was called the Rupan Deol Bajaj case. Here again, this she was speaking about it herself, and she's come out on a lot of TV shows, etc., to speak about it, and therefore the use of her name. In her case, she was an IAS officer, and she was bottom pinched by this IPS officer at a party, you know, that they had. So now the question was two things. One, it was seen as, well, you know, the IAS officer, her workplace is different. The IPS officer, his workplace is different. But an IPS officer does engage with the IPS officer in the course of work. And even if this party may or may not have been related directly, the point is that there is a work relationship. It may not be that of, you know, in the same workplace as such, but it is a work relationship in government. So the thing is that over there, one of the conversations that happened at that time through the courts was that this is a trivial act, you know, just about bottom pinching. Why make such a big issue about it? But as later the Verma committee said, it is these small things that we ignore that result in big acts, and therefore it doesn't cease to be an offense because it's looked at as what is called you know, a small act or a trivial act. And the next thing was that another conversation at that time was, because the IPS officer who was the responder, who was the accused, was the DGP. He was not just an IPS officer; he was the Director General of Police, and he had been instrumental in kind of dealing with some major situations and bringing them under control. Now, the point that the women's movements have always made is that we are not making a statement about the other aspects of their lives, you know, whether they're very good. Because, for example, we also had a case in Goa University where the professor said, tried to say, he was a professor of political science, and he said he's written books on cabinet governance. So we say, yes, okay, you've written books on cabinet governance, and they may be even very good books, but so what? So that doesn't mean that gives you a cover for your acts of sexual harassment. So we are trying to distinguish that whether the person is a respectable person or not a quote unquote respectable person, if he's in the box as a perpetrator, he has to defend himself, and defend himself on the points on which he's been accused, and not to say that he's written this thing or he's done these heroic acts, or not for his supporters to say all these things, because they are not relevant to this case. So then the other question, as I said, is a party a workplace? So this is also pretty much discussed, because if you are, you know, if there is a party of officers, then it is pretty much a workplace in that sense, because these are the people who engage with each other in governance. So it in a sense, it was a case of a sexual harassment at the workplace, though it may not have been in her office or in his office. So this is again why the word workplace has got a very wide definition even in the current law. Next. So this is what was called the Secretariat, you know, what was called the Secretariat sex scandal case. It is basically here the complainant, this is in Goa. This was where the speaker had was accused. Then speaker was accused of sexually harassing his employee. She did not take recourse to the law because she didn't see any hope. At that time, we didn't have Vishaka, we didn't have any of that. So she didn't see any hope. And then, you know, at that point, soon after she kind of approached certain activists, basically the trial was fought on the streets, where there was a long drawn agitation. Now, she was in a contractual position, and of course the issue was one of unsafe work conditions. And then no sooner the news broke out about her complaint, there was a character certificate for the accused given by all the remaining employees. So now you can very well understand that if the other people, and that too in a powerful position of speaker, if the other persons are all also working, and that too on a contractual basis, they can be terminated anytime. So therefore, these issues would prevent a lot of people from saying the truth, from being witnesses to the truth, or from not giving these kinds of situations would compel them to sign character certificates, so to say. So these are things that were also taken into account, because if you say that such a person is a very good person, he'll never do this, this is not relevant for the case. Similarly, what is the past of the woman is not relevant for the case. We are on the incident that is complained about. That is what this case sought to, in many senses, in many ways, highlight. Next. So that is how then there was this organization called Visakha and others who decided that, because all these cases were being discussed, talked about, etc., primarily Bauri Devi's case, but all these cases. And of course, also internationally, there were other cases that were in discussion. If I recall right, the Anita Hill case, where the accused was somebody who later got appointed as a judge. Here, in this case, the petition was set out as a case of fundamental rights, and that you need a special law to deal with sexual harassment in the workplace. As I said, it's not always easy for a woman to reach the police station, and it is a question of what will happen to her job, because she requires her job. At the same time, she can't bear all this, and she might just have to leave her job because of all this. So how does one deal with such a situation? So therefore, it was put up in these terms, in terms of the right to practice any trade or profession of one's choice, the right to life and liberty, including health, because we found that a lot of people would be very badly affected, especially mental health wise, when following sexual harassment, because of the not necessarily the bodily harm, physical bodily harm that it causes, but because of what it means for the women in terms of the violation of their bodily integrity. And therefore, we had this case was put up in terms of Articles 14, which is about right to equality, Article 15, which is about non-discrimination, which means that a woman should be as easily able to work at a workplace like a man, and should not have hazards, like a hazard of a workplace, in terms of sexual harassment. So therefore, Article 15, which is about non-discrimination. Then Article 19(1)(g), that is, as I said, to practice any trade or profession of one's choice. And Article 21, right to life and liberty, including health. So the Supreme Court said that these rights stand violated because of the if on account of sexual harassment in the workplace. And so it dwelt on this. Then it looked at the judicial imperatives that that judges are not supposed to be passive spectators to everything that's going on, and they do have a responsibility of enforcing, as one can say, the Constitution. So in that sense, they drew on their the principles which required that they take positions on these issues. And then they also looked at the fact that India had ratified various international conventions. This is not to say that there are no provisions in the Constitution of India, but in keeping and in tandem with those provisions of the Constitution of India, there are also international covenants which India has ratified, is a signatory to, it has ratified. And those international covenants also require that women should have a safe workplace, rights to equality, rights to substantive equality, or equity, as was discussed yesterday, the concept of equity. So therefore, the court said actually it is the duty of the legislature to enact a law, but till such time as the legislature does not enact a law, you can't have women's rights violated because there's no law on this subject. And therefore, they prescribed certain guidelines, which included setting up a committee to deal with sexual harassment at the workplace. You know, so every workplace was required to have such a committee. So this is and then they also looked at that you need to have an external person. Now the thing is that they also recognized, I presume, that not every woman can go to the police station and produce that kind of proof, because it's happening at her workplace, and if it happens at the hands of her superior, it's very difficult for her to gather that kind of evidence, the extent of evidence that is required for a police case, for a case at the police station, a criminal case. So therefore, this was a mechanism, you know, which was devised, which did not require that level of evidence of evidence, and that is how they had this concept of the committee visualized. Also, that its chairperson would be a woman. There would be an external person so that everybody is not under the pressures of the employer. So there is an external person who has to be there. So this is how, this is what in short was the Vishaka judgment. Next. Now, this Vishaka judgment, after this Vishaka judgment, I also want to say there are a few other cases, because that's an important lesson that the women's movement had learned from the other experiences, that if you fight for something, then you get a law. You can't sit back on your laurels. You have to you have to engage with that law. After all, you fought for that law because you felt that the law was, there was no you know, shelter that somebody could take under the law. So when you get a law, you have to use it. You have to use it when there such cases arise. And that is how a lot of such cases, women's groups mobilized around some of the cases, again, which were again galvanized into at national level. For example, there was a case of sexual harassment of a student by her PhD guide, and then in that case also women's groups from all over, including, for example, women's groups from Goa, wrote a letter to the Supreme Court of India, to the Chief Justice, saying that you know, we have these guidelines but they're not being implemented, and the educational institution is a workplace no less, you see. So that is how they were fresh, you know, deliberations on these issues. So the issue was constantly kept. Otherwise, what happens is, when a new law is enacted, there's a lot of noise, and for some time something happens, and afterwards it goes into the back burner. So therefore, like this, we had some judgments that that emerged from some of these challenges, because the law was not being implemented, or the committee was not being constituted, or if the committee was constituted, it was not being constituted in the manner it should be, where there has to be an external person. This still happens even today, by the way. So these were some of the issues that that got raised by the at various levels. While all this was happening and the movements were discussing, and there were various drafts of the sexual harassment law, because remember, as I said, the Supreme Court had said these are the guidelines, still a law is enacted. So while all this was happening, various people were drafting, you know, various groups or at various institutional levels, drafts were being made of the sexual harassment of women at the workplace law, and those were being discussed. There were various drafts circulating, and we were having these discussions. But it looks like that there is a response only when there is a case where groups are collectively fighting, and a lot of it also depends on that particular case as well. So it was during the time when it was the Nirbhaya case or the Jyoti Singh case that there was again an outrage. Now, Nirbhaya's case was not a case of sexual harassment at the workplace. She was returning from a movie. So by no stretch of imagination, we can say it was a case of sexual harassment at the workplace. But the government of the day decided that let us look at everything to do with sexual harassment, the law on sexual harassment, especially the criminal law. And that is when the Justice Verma, a committee which was chaired by Justice Verma, which is popularly called the Justice Verma Committee, was constituted to look at amendments to the law. And that is when the Justice Verma Committee did not confine itself to only looking at what changes need to be made in the law, the criminal law, but it looked at other options because of these situations where not everybody wants to go to the police station and go through that rigor of the police station, and considering the specificities of sexual harassment at the workplace. And that's where Justice Verma's the committee report has a chapter on this subject, in fact. And some of the things that he said, I've set out here. One is that conciliation cannot be a first step in redressal, which means that it can be a first step after the case comes up and people say, okay, we want redressal, or if they choose redressal. But it cannot be that you first go through a conciliation, and if that doesn't work, then you go through the case. No. So that is very clearly said, and that principle is now finding its presence in the present law as well. The next was that the committees must be trained to fulfill their duties. So as I said, one thing is to have a law, but many times people may not know what the law is. So the survivors or the victims would not know what the law is, and the committee also wouldn't know what their duties are, or the employer doesn't know what the duties are. So there has to be an orientation at the workplace, and that again is also found place in the current law, which says that there has to be an orientation for the workplace, for different sections of the workplace, and there has also to be an orientation for committees, because not necessarily the internal committees are versed with law as such. So there has to be an orientation for the committees as well. They also said that the subjective perception of the complainant is very important, which is why in the Vishaka judgment as well as in the present law, they talk of unwelcome. So it doesn't mean that, for example, if say there was this case where the one professor said he was giving a fatherly pat to the student, but the student didn't accept that. So you cannot, it is not the perception of the accused, it is the perception of the complainant that counts. So he cannot go on giving fatherly pats, saying he's giving fatherly pats, when the complainant is not comfortable with it. It's unwelcome for her. So this is again, therefore the word unwelcome figures very strongly in the law. Then the importance of covering every female member of the workforce, of the workforce. This means that the Vishaka guidelines are being implemented in the workplaces, the organized workplaces. But what happens if there are vendors? Now, let's say street vendors. Where will they go if that's their workplace, on the street, and where will they go? So therefore, there was a need to have some sort of mechanism that would deal with sexual harassment for informal sector, for the unorganized sector. And that is how you now have a mechanism in the law which deals with the unorganized sector. Then they said that you have to acknowledge that not everyone can make a complaint in writing, because there are some people who maybe they can't write, maybe they're too traumatized to write. So, but they would speak, and then with some assistance, they would be able to have their complaint put down. Or so therefore, it's very important that to recognize these realities. So basically, the law is recognizing the ground realities in terms of ensuring access to justice for the victims. So that is why, again, this is also there taken into account in the law. Then there was no specified time limit. Then there was action. Okay, then there was need for action, because very often, okay, the case is going on. What happens in the meantime? Is the survivor supposed to face that person at the workplace? How is that possible? Would it be? Does the survivor feel threatened by the presence? These are questions that need to be asked, and therefore, that also today the law has a provision that says that that provides for interim measures. Well, while the case is going on, till the case comes to an end, certain interim measures, that options for the woman to kind of move to another place, or for the respondent to be moved to another place, or to be suspended, or whatever, which the employer decides, but the feedback has to be taken from the woman. So then there was and then it said that there are There should be no provisions that enhance a sense of victimhood, that there was no need for a false complaint provision, it also mandated monitoring. There should be like mandated monitoring. See, there is this thing generally that every law needs to be monitored, but it doesn't really happen. So therefore, it was necessary to see that it is happening in terms of the implementation of the law continuously, and that there should be a diverse committee. So that is why, if you will see that in the composition, that there is a diverse committee, and that cross-examination need not happen in the presence of the accused. So these things are to ensure that the victim is comfortable, she's not further inconvenienced or does not face secondary victimization. Next slide, please. So next, yeah, so this is the law. So, you know, if you can see the law, the name of the law is Sexual Harassment of Women. So it's about women being sexually harassed. It does not cover other genders being sexually harassed. It is about sexual harassment at the workplace. And then there are three aspects that are being dealt with by this law. It is part of this new genre of laws, that this new kind of laws, which don't only talk about saying this is an offense, or this is what you can do if this happens to you, but they also look at making sure that that everybody at the concerned place, or everybody who can benefit from this law, should know about this law, should know that sexual harassment is not to be tolerated, that there is zero tolerance for sexual harassment, and that it's an offense, and it's also a workplace violation. It is also about making sure that the law can be that the sexual harassment can be prevented. So and the prevention is largely a responsibility of the employer. So this law is not just looking at the perpetrator of sexual harassment. It is looking at that, but it is also looking at who has what kind of responsibilities, because the state has responsibilities. It is a fundamental right of a woman to work free from sexual harassment, and therefore the state has responsibilities to make sure that this happens, and that the state will have to make sure through mechanisms that are there in place for which every employer, etc., have to comply with. Next slide. Next slide. Yeah, so the sexual harassment, you might all be familiar. So basically what I want to say from this, you can see this here, physical contact and sexual advances, making sexually colored remarks. So it is not restricted to what originally used to be called the word molestation. In fact, the word molestation is not even used in the criminal law, but that's a popularly used word, which meant physically touching a woman on her breast, etc. That was seen as, you know, outraging her modesty, was seen as sexual harassment, and other acts were not seen as sexual harassment or physical contact. Let's say, you know, there are cases where we've come across where, you know, a student asks for somebody to show her how to you know, operate something on the computer, and the professor comes and tries to feel her hand. So now this is not her her what is called private part, is not a breast or whatever, but then this amounts to sexual harassment because it's a conduct of sexual nature. So it's physical that's why the word physical contact and sexual advances. Then making sexually colored remarks. So it's not just about the physical, but also verbal, showing pornography. This I guess you can understand. Demand or request for sexual favors. So here you say that you know, will you, so you don't make a remark, but you're asking that will you will you do a one night stand with me, for example. Now this is and you know, and in the manner in which it is said, there's also a thing that you know, somewhere that you will if you don't comply, you will not get leave, you'll not be granted leave, or you will not get marks, or you will your reports, you know, the CR confidential reports will be fudged. So that is why it's called quid pro quo, which is referred to in section 3. That means, you know, you give me sexual favor, I will give you this. So, you know, even if that happens, and the woman obliges because she's at his mercy, that is sexual harassment, because there is no consent. And here I would like also to bring to remind you that the word consent has undergone a lot of discussion. There's been a lot of discussion on the word consent. And today it's not just about, if someone says yes, it's a question of in what circumstances the person said yes as well. So, and also in the criminal law, the word has been very specifically defined to say that there has to be explicit consent. So you can't say that suppose a woman goes along, suppose somebody says, come with me, let's go to the hotel, and she walks back past, that means she's consented to sexual harassment. So there has been all this discussion which one has to bear in mind, and there is the jurisprudence on it also, which one has to bear in mind when one is looking at a case of sexual harassment. Because very often I have myself come across cases, and initially I used to say, but I used to see that girl in his car, just to go in his car. But then I understood over time that they didn't have a choice but to go in his car. Sometimes he would blackmail her, saying that if you don't come in my car, I will report to your parents that you are going around with this boy who they may not approve of. So you see, there are all these factors. So what is seen is not what. So we have to uncover that whenever we are looking at a case of sexual harassment. So as I said, demand or request for sexual favors, other unwelcome physical, verbal or non-verbal conduct of sexual nature. So these are all, this is the definition, quid pro quo, hostile environment. Okay, now quid pro quo I already explained. Hostile environment is when, for example, the whole, let's say everyone on their desktops, suppose it's a computer room, and everyone on their desktops has got a porno picture. So they can very well turn around and say, you don't want to see it, you don't look at the computer. But if there is that embarrassing pictures all around, then you can't function in that place. So they cannot now turn around and say, look, I didn't show you pornography. You see, so they've in that sense they've created a hostile and work environment. So this is something that also constitutes sexual harassment. And humiliating treatment affecting health or safety. Of course, at every point of time, it is connected with acts of sexual nature. So from this, move to the next one. Next slide. So therefore, it does not. As I said, it has to do with acts of sexual nature. Therefore, it does not cover. For example, if the boss says you women don't have brains, so then that wouldn't be sexual harassment per se. But if he ends up saying you women don't have brains because you are not submitting to his request for sexual favors, then it is sexual harassment. But per se, if he says, because there are sexist, so the sexist comments are different from sexual harassment. So this we must remember. That is a gender, that is a what you call a grievance against gender bias, which is of a different nature. So suppose the boss does not grant leave because there is work to be done, and there's no way that work can be done without keeping a person overtime, keeping people overtime. Then purely if it is that, then that doesn't amount to sexual harassment, because these things, if the law provides that they can, then they can, unless you can see that there's a distinct connection as to why somebody is being kept overtime. So same with overtime duty or denial of leave, or or let's say suppose there's lack of access to drinking water. Now doesn't provide, somebody is a sadist, let's say, and doesn't provide for water at the workplace. So now that's not a sexual harassment. Because you're a woman and you're facing it, it's not sexual harassment. But if it is because you're not giving in and he wants to trouble you, then it becomes sexual harassment. That's why I said, unless the same are connected to the actual act of sexual harassment as defined. Next. Yeah. So I won't read this, but this is there in the law, but basically enough to say that employee doesn't mean only somebody who's like a permanent employee in an office or a factory, but it includes a contractor with a somebody who's employed with a contractor of the principal employer. Let's say, for example, if it's a if you have potters, let's say the office quarters, and the office quarters, the employer employs a contractor to paint the place, okay, to paint the quarters. Now here the let's say say somebody who comes to paint the quarters sexually harasses the employee who's staying in the quarters, then that is also sexual harassment at the workplace. Just to give you an example. So it's not about strict, there's not a strict expression, because this was another thing that was happening, that constantly people were being told, oh, this is not, you know, you're not an employee of this place. Or, you know, they would not recognize that she's an employee because people don't maintain their employment records, you see. So they don't give an employment letter, etc. So they would just say that, you know, this person, she does not work in my workplace. So this will not be covered. So therefore, to take care that it is covered, this definition is vast and expansive. As I said, as you can see, it also includes trainees, apprentices, etc. As far as employers are concerned, it's the same thing, that it's the head of the department, organization, undertaking, or if it's some, you know, workplace, it is any person responsible for the if they're not, you know, government offices or something, any person responsible for the management, supervision, and supervision at the workplace. Okay, so this is broadly what an employer covers, because this is why the definition of employer is important, is because it's the employer who is responsible for taking action. Remember that we often think that internal complaints committees are the ones that have to take action, but it is actually the employers that have to take action. Internal committees are supposed to inquire into a grievance of sexual harassment, come up with a finding whether there was sexual harassment or not, and if they come with a finding that there was sexual harassment, they have to recommend what should be the penalties. So next slide. Yeah, workplaces, as I said, there can be all kinds of workplaces, and as I already pointed out, it can be hospitals, nursing homes, it can be any of these various workplaces that are listed, any workplace that you can imagine. But in addition to that, if you look at point 5, any place visited by the employee arising out of or during the course of employment or transportation by the employer for undertaking or engaged in transportation by the employer for undertaking such journey. So for example, if there is a company bus and you face sexual harassment in that, you know, in the bus, then at the hands of the, let's say, the conductor or somebody there in the bus, then that's also the workplace, because it's in connection with work that you're commuting in that bus to the workplace. So just to tell you that it is wide enough, and it's talking of a dwelling place or a house, because you also have a domestic worker. So for her, the dwelling place or house is maybe the place of sexual harassment, where she faces sexual harassment. So next. So yeah, just to say that the employers have certain obligations. They have to constitute the ITC. They have to create an enabling environment for a committee to carry out its responsibilities. They have to disclose the details of the committee everywhere at the workplace, so that every employee knows that it is sexual harassment is prohibited, and X, Y, Z are the committee members. These are their phone numbers, etc. They have to formulate and widely disseminate a policy which will look at what is their outlook towards this whole issue, and they have to carry out employees awareness programs. Next slide. And similarly, they have to see. Now, this is another critical thing, which one of the papers that I gave you as a reading addresses, that there are different organizations which have different service rules. So these inquiries have to keep in mind those service rules. So, for example, the government employees are governed by the CCA rules, and this point about sexual harassment and the specificities of how inquiry is to be conducted when it comes to a government employee are written in those rules. So therefore, this committee has to keep those rules in mind when they're doing the inquiry. Similarly, so the government employees or teachers of government aided colleges, etc., they are governed by the CCS rules. So therefore, what it means is that first the committee has to conduct a preliminary verification to ensure that there is a grievance of sexual harassment. And it's only once that preliminary verification is done and a report is filed, and then a charge sheet is sent to the respondent, as the person is called, then only when the person has to give a reply, and then the committee again begins a whole investigation. So therefore the service rules are critical, and it's also important that they specify that sexual harassment is a misconduct under the service rules, and they implement the recommendations made by the committee for the safety of the complainant. So once the report is prepared by the committee, the employer is bound to implement the recommendations made by the committee, unless there is a after giving a show cause notice as to the person who's accused, who's called the respondent in this law, as to why they should not implement the recommendations, the findings and the recommendations made by the committee. So yeah, and then yes, move on to the next slide. The composition, you can read it in the law, basically saying that the presiding officer should be a woman, as I mentioned, 2 internal members, 1 external member, and this is a minimum composition, okay? And at least 50% have to be women. The chairperson has to be a senior level woman. And this is issue that often came up because sometimes a subordinate was doing an inquiry over a senior level, and that created other dynamics of sorts. So they said that it has to be a person who's a senior level at the level of chairperson. Next. Yeah, so the composition as far as the local complaints committee. Now, this is as I mentioned, this law is taking into account sexual harassment at the workplace in the informal sector, where you can't have, for example, if there are vendors, like 4 vendors in a place, or 3 women working in a field. Now you can't have a sexual harassment committee at that workplace. So therefore there should be some venue for these people, because you can't have let's say somebody forming a committee, let's say in every field, or let's say on every street on which 5 women are there. So therefore, because taking into account the specifics of this situation, the laws provides for the constitution of a local complaints committee. So the workplaces, the organized workplaces that have 10 or more employees, etc., have got a internal committee. If they don't have an internal committee because they do not, because of these other factors, that they are less than 10, or that they are they're just they're an unorganized sector, then you have this local complaints committee. Its composition, again, chairperson has to be a woman who is eminent in the field of social work. 1 member has to be nominated from that particular block, taluka or tehsil or municipality in the district. Then 2 women have to be nominated from government and NGOs or associations committed to the cause of women, a person familiar with issues relating to sexual harassment. At least 1 of them has to have the knowledge of the law. Unfortunately, fortunately or unfortunately, I would say, this requirement is not there for the internal committee. So what happens is that here somebody is there, or at least is required to be there, who has knowledge of the law. And but in the other committee, they don't have that requirement, which is one of the limitations actually of the law, because then a lot of times people don't know how the inquiries to be conducted. And then at least 1 of the nominees shall be a woman belonging to the scheduled caste and the scheduled tribe, or other backward classes or minority community, notified by the central or state government from time to time. So the concerned officer dealing with the social welfare of women and child development shall be a member ex officio. So this is basically the composition of the local complaints committee. Next. So I'm quickly running through this, that basically the internal committee has to receive complaints, conduct the inquiry, submit a report, and in its report it gives recommendations. It does not order. It gives recommendations which are given to the employer. So this is basically a grievance redressal mechanism at the workplace. Receiving the complaint, your complaint is supposed to be kept confidential. You can give it to any member of the complaints committee, or in a designated box or something that is available at your workplace. The inquiry would follow principles of natural justice. So it doesn't mean that just because someone has complained, it is to be taken as the gospel truth. But at the same time, it also doesn't mean that When a woman complains, she's to be disbelieved, as used to happen before. So there has to be a chance given to the other person to give his say on the matter. And then it's for the committee to assess the situation. Always taking into account the ground realities, because, you know, for like as I gave the examples before. And then they come out with a report after. Now, the thing is that as part of this inquiry, you take statements of people. Those need to be, please remember, those need to be recorded. Because if you can't say she said this and write 2 lines of what she said. You have to say what exactly the person said, what exactly her witnesses have said. And then the other side has to have a chance to cross-examine. They don't need to come face to face with the person. You can have a 2-way mirror. Nowadays, you can have video conferencing. All these measures are there. But it needs to be, the other side needs to be given an opportunity. And after assessing everything, like for example, the other side may say, you said I am guilty of sexual harassment on X date at X place. But on X date at X place, I was at this place and here is my CCTV footage. Then you will have to take that into account. You see, you can't miss it unless the woman says, I don't remember exactly which date. Then it's different. But if she says a specific date and that person is able to point out that he was not there at that place, then this is something you also need to take into account. Next slide. Yeah. So there are, despite all these mechanisms, there are many people who have not been reporting, and which is why the Me Too movement emerged. And then you had these things like, why now after so many years you're talking about it? I don't believe you. What were you wearing? You must have been wearing a low neck dress or some revealing dress. Where do you have proof? Proof is always seen as something like, you know, hard proof. Like for example, if you have a recording, that might be seen as fairly hard proof. But if you or you know, like a message on the mobile. But the point is that proof is not necessarily only that. If a woman should give testimony and there's no other witness, then even that is proof. If she stands the cross-examination and she stands the scrutiny of the committee. So it is not that she's only speaking. She can be questioned by the committee. She can be questioned by the respondent, but of course, keeping in mind the safeguards that are provided in the law. So the Me Too movement raised a whole lot of these issues because these committees were being very traditional in how sometimes like almost operating, some of them operating like Kap Panchayats and saying, listen, why are you complaining? You're disturbing the name of, spoiling the name of the institution, etc. Next. So the Me Too movement actually brought out some of these issues like socially disabling conditions for women to speak up, the institutional barriers that even due process can be configured differently for different sections of women. Like, you know, how do you deal with a situation where you have due process, but the woman is you know, intimidated and told that you know what power I have. No, I am somebody of the ruling party, or you know, I am a karyakarta of the ruling party. You know what I have. No, and these days, you know, some more things can be even said given the developments in recent times. So the thing is that there are these factors which will impede a woman from speaking up. So these are also some things that that have been highlighted and have been seen as the limitations. Next. So the takeaway is sexual harassment is an act of power, not lust. It is a violation of fundamental rights. Work is not only that which happens in offices and factories. Naming what is perceived as sexual harassment, because basically sexual harassment is not only as I said, physical, etc. They've talked about an accessible, gender sensitive process, because it's about complaining. It's about a certain time frame within which the committee has to dispose of the case. Mandatory orientation and monitoring. These things have been woven in the law itself. They're not something that, you know, somebody says, you should, there is a law, you should create an awareness, but it is mandatory. If they don't, they can face consequences. If they don't constitute a committee, they can face consequences. So there is that monitoring that is required to be done. And the law is speaking about, as I said, prevention, prohibition, and redressal. Yes. Yeah, so there are the limitations which so, you know, for that, when a sexual harassment policy is being framed, the workplace can think of working on something where it takes into account that would the policy have made a difference to any aggrieved woman, because everything cannot be spelled out in detail in the law, and you have to take into account the specifics. For example, if it's an IT sort of setup, then you'll have to take into account certain other specifics. So that policy of that particular workplace can bring these into their workplace to make sure that the experience of sexual harassment is validated by the law, as in it is recognized by the law, and to ensure that there is accessibility to the law enforcement mechanism, to ensure that an enabling environment is created. So if you have a vast campus, then you have to make sure that there is lighting, etc. So that should be woven into the policy. So these are the things that need to be there in the policy, but they're not there as of now. Most people don't even have their policies in place. So I'll end here. I think I've taken a lot of time.
Thank you, Albertina. Now you'll have to answer your 6 questions in the Q&A box only, because we have exceeded the time limit by half an hour. And the next speaker is already waiting. So, but there are 7 questions for you. You can see in the question box and you can answer. Yes. Most of them you have taken care of in your exhaustive presentation, but it was really brilliant. The journey of women's movement and the legal activism against sexual harassment at workplace, you have brought out beautifully with all the details, nuances, and also case studies. So it was really a very, very good and very educative session. Thank you.
Thank you for the opportunity to engage.
Thank you so much, Albertina, ma'am. Vibhuti, ma'am,
now the questions have increased to 9. Albertina, you have a lot of work to do.
Yeah, sure.
Yeah.
Thank you so much, ma'am. If you could please answer the question in the text box. Meanwhile, I would like to introduce our next speaker for today, Dr. Amar Jesani, independent researcher and teacher, bioethics and public health, editor, Indian Journal of Medical Ethics. Please take it from here, sir. Very warm welcome.
I need to get off this.
Good afternoon. Are you able to see it?
Yes, sir. Please go ahead.
Okay, that is great. Well, we have 40-minute session, and I will try to finish as early as possible so that we can have what I would call face-to-face some discussion rather than writing in the question answer box. You know, I'm not a good writer. I mean, I love talking. Anyway, as you know, that abortion is a very controversial area, and it has been so from long time, and I'm sure it will continue like this for a very long time to come. Many of you who have read Indian Journal of Medical Ethics may find some of the things that I'm going to talk repetition, but this is the journal that you can have a look at it. It's 30 years old. It is an academic peer-reviewed and index journal, and at the same time it is open access, so you don't have to charge. Nothing is charged for reading 30 years issues which are available on the website. If you want a print copy, you have to subscribe. You have to pay. Otherwise, it is available free of charge. Even the authors who publish in this journal, they are not charged. So normally, open access journal charges from the author. We don't do that either. It is a pay what you like kind of situation there. And it's a multidisciplinary journal. It's not a journal of medicine, although the name suggests that it is medical ethics, but it's a mainly journal of bioethics. And the multidisciplinarity includes social scientists, lawyers, the physicians, doctors, and the philosophers, and all kind of people. And we do publish a lot of stuff on humanities, including literature. So have a look at this journal, and it has published a lot on reproductive health ethics, and that is simply because we believe that the bioethics movement or bioethics discipline that emerged in India in last few decades has learned a lot from the women's movement and its fight against population control, the unethical contraceptive trials, and the issues related to the assisted reproduction, as well as certain things like sex determinations and all kind of stuff. So women's movement contributed quite a lot in the development of this discipline. So let me focus on the abortion as an issue in the field of ethics and law. I'm not a lawyer. I come from medicine, and I haven't practiced clinical medicine, but my work is more in public health and social science research in the field of health systems and health services. And so I'm going to give you a very broad area of law and ethics, not very specific about each provision in the law. So we start with what is morality and ethics, and also look at what are the specificity of the reproductive health ethics. Then go into the history in relation to abortion, religion, medical profession, and law, and then go into the lot of issues related to the ethics and abortion, conservative position, liberal position, moderate positions, and all, and the position which is based on the women's reproductive rights, and also talk about the instability of moderate positions, and then have dilemmas and challenges. They look quite a lot of issues, but they are all covered in some 13, 14 slides. So hopefully we will have more time to talk about it. So those who are not exposed to the idea of ethics and morality, I think it is for them just to understand that when we talk about morality, we are talking about the moral that we pick up as individuals from our culture, our religions, and all. So it is like a first order beliefs and practices, which has a lot of values. I mean, these are all family values and social values and religious values and community values in India quite a lot, because there are a lot of values connected to the caste issue and various other strata, So these are each value has certain duties, that if you believe in certain thing, then it casts certain duties towards the society, towards the other fellow human beings. So that is what we call a larger gamut of moral issue. The discipline that I come from is ethics and bioethics, which actually does what we call explicit and philosophical reflection on the moral beliefs and practices. So if somebody says that, well, as a tradition, we believe that abortion is a bad thing to do, then it is our job as a part of the discipline of ethics to reflect on it. That is it really like so? If so, what are the evidences for it? What are the arguments for it? What are the arguments against it? And what exactly should be the right position? So from that, when you talk about position, we come to what we call normative or applied ethics. That asked question is not what is the belief system or what is morality in the society, but to go beyond it and say what ought to be there. I think that is where we have to all debate and discuss. So existing state is not denied. It is it's a moral imperative taken into consideration, but they are also reflected upon, dissected, and argued upon in order to come to some position about what ought to be there. So that's how you will find that even when we shifted from say having a criminalization of abortion to the legalization of abortion, we shifted from what was to what ought to be, and that's how the new law came into being in 1971. So that's how it is. Coming to the reproductive health ethics, what is the distinctive things in it? And I found I did a lot of work on issue of reproduction, and in my research also I was quite involved on research on that. And the reproduction is actually normal biology. It's not something that is extraordinary and pathological. One shouldn't medicalize the normal reproduction. So it largely deals with healthy reproductive biology. Only a small part, which is pathology, where there is an illness related to the reproductive health, that goes into what I would call where the medical intervention is required. So the predominant users of the reproductive health are healthy women and men. Men, unfortunately, are not using it as much because reproduction is put on the head of women in our society. So when reproductive health services are obtained, who is the elephant in the room? And that is the third party, that is the social morality, which comes from religion, patriarchy, and broader societal or communal morality. It also stigmatizes the idea of abortion. And so stigma is very much connected to certain stereotyping, saying that those women who do it are not of good character, or they are committing sin against their faith. So this elephant in the room, what does it do? It shifts the focus away from woman who is seeking care, who needs certain support in the reproductive health. So from the woman, it goes into the rights of the other people. Like say, what is the right of husband here? If woman wants to have an abortion, why can't husband have a right to give consent rather than woman having a consent? Or even if woman's consent is acceptable, it should not be made acceptable without the husband's consent. Or the family has a more to say about it, that how the woman's reproductive health should be managed. Or what is about the right of the fetus if she is looking for abortion when she finds that she doesn't want to have more children? She has no control over her own sexuality because that is the husband who impregnates her against her wishes. Or even if it was with the wish, what about her right to change the decision that she had taken there? The other third party, another shift the whole focus from woman to demography. Oh, do we need population control? For population control, do we need support of the abortion, right? Or is the abortion, if it is not done properly, causing more maternal mortality and creating medical issues? Okay. Or we have made commitment in the international fora for achieving certain targets for the reproductive health. All kind of things you will find, and these are all so many moral as well as other elephants sitting in the room, which takes away focus from the woman to the other issues when she is looking for abortion. Okay, now religion and medicine. And what I discovered, and I have been writing on the subject for almost more than 3 decades now, and I discovered in my initial forays was that there is a lot of overlap between medicine and religion. So all religions are opposed to abortion. I didn't find a single one. There may be some opposition, maybe a little partial in the sense that some say that, well, for a certain number of days, there is no ensoulment, or there is no, whole human being is not formed, and that kind of, till then it is fine, but thereafter it is a problem. So, but basically, most of them would like to oppose the abortion. They said that, well, the fetal life is more important than the wishes of the woman. So this is a very important thing that I discovered. In India, Hinduism is also like that. That does not mean that, despite that, we cannot have a different kind of abortion law. The religion in 1960s and 70s did not play as a big role in determining what should be the position on the abortion. But a century before that, that is in the 19th century, you'll find that the Hippocratic Oath and, in the ancient time, with medical, ethics position, all of them, they all are talking about not doing abortion. Hippocratic oath is also like that, is a classical one of the ancient time. If you take the Charaka Samhita, there is a whole big code of ethics there that also takes the similar position. And the modern code, like World Medical Association's Declaration of Geneva, they all will say that, well, they will not say that women's right to abortion should be respected by the medical profession. They will say that you should carry it out if the law of your country allows, kind of stuff. So it's neither here nor there. It's not a recognition of the moral or ethical position within the medicine. Who were the early abortionists, before the 18th and 19th century? They were all women. The organized medicine was more for the elites of the society. The common people relied on traditional practitioners. And for women, they were lay women, they were the healers. And they were providing the abortion. It was only in the 18th and particularly in the 19th century. 19th century was the turning point where the medicine gets scientific and the profession of medicine emerges. It was only in 1857 that General Medical Council in England actually recognized legally by the state power the medicine as a profession and made them to register with the medical council, and that registration was necessary to do the medical practice, and that is the beginning of professionalization. And they competed with this traditional midwives who were providing services to the women. And that's how you'll find that in 18th and 19th century, those were the women who were displaced by the rising obstetric and gynecology profession. They were the ones who were termed witches. They were burned. They were, might go out of their occupation, and gradually the professional medicine took over. In 1859, as early as that time, American Medical Association passed a resolution asking the government to outlaw the abortion. This is there is a lot of debate about the US, as you know, with the recent Supreme Court judgment. The American Medical Association in mid-19th century played a very negative role on the women's right to abortion. And it was in 1869 that the church comes out with a definitive position saying that undertaking, doing and getting through the abortion is a sin, and it can lead. It's kind of an affront to the faith, and it can lead to the excommunication. So thus in 19th century, in mid-19th century, 1869, around 1870, that medicine and religion came together to criminalize abortion. And that criminalization continued for 1 century. It was only in 1969, that is in England, abortions were legalized. In India in 1971, we were under British colonial rule, so they had also criminalized abortion in India. And it was in 1972-73 that in a Supreme Court judgment in USA legalizes. South Africa also in 1971 around that liberalizes abortion. So for a century, almost everywhere in the world, abortions were made illegal and criminal. And yet women continue doing abortion. There was no way that abortion could be stopped. Only thing were that they were underground, and there were a large number of them. Post-independence in India, there were no strong anti-abortion movement in India. At the same time, there was no strong movement demanding that the abortion should be made women's rights and the criminalization of abortion should be stopped. But what happened in India, as you know, that there was a whole imperative of population control. They wanted to control population. Demography was very important. And India was one of the first countries in the world to start population control movement. Or the state started the family planning and family welfare work. And so the whole issue of providing contraceptives and sterilizing men and women, and all of you know that how family planning was carried out. So They needed abortion, medical termination of pregnancy as a backup to the failure of the contraceptive. That was very, very important in order to sustain the population control movement as well as family planning measures. The other problem that was that India had at that time very high maternal mortality. It was more than 500 maternal deaths per 100,000 child birth. It was a massive, one of the highest in the world. Today it has come down considerably down, in less than 50. But it was at that time considered to be a kind of a shameful, situation. And more than 10 to 15% of the maternal deaths were because of the septic abortion. Women were getting abortion, but were getting illegally and in unhygienic conditions. And there were large number of maternal deaths because of that. These two acted together. I hope some of you or all of you have read one of the paper of mine, which is old one, 1994, that I wrote in Economic and Political Weekly with Aditi Iyer. Where I have explained that Shantila Shah committee, which was formed, which submitted its report in 1966, which wanted abortion to be legalized for the demographic reason as well as for the medical reason. They said that if the properly trained doctors do the medical termination, then septic abortion will go down and the maternal mortality will not take place. And so the liberalization of the abortion, medical termination took place. I have also argued that it was more of an utilitarian position. It was not a position to recognize the woman's right to abortion. It was made available only in certain conditions, including contraceptive failure, including saying that, well, women will feel psychologically disturbed or something like that. It was not on asking, saying that, well, woman, irrespective of whether she needs or not, but irrespective of whatever her situation is, if she needs it, she can get it. Nobody should ask any question why she wants to have it. And another thing they did was that it can be done only by the doctors. So doctors who were the ones who were involved through their medical ethics, conservative medical ethics in prohibiting abortion. They were also the ultimately beneficiary of the liberalization of abortion. That do abortion, but do it. All of them should be done by the doctor. And most of the abortion at that time was surgical abortion. It's only in last 20 years that we have now medical abortion where doctors' direct involvement may not be there. So right to abortion, but the right, and the other part that was that it opened up that way a kind of facilitation for the women to get the abortion if they want. But at the same time, it did not provide. Government did not say that, well, if you go to get abortion done, say in primary health center, then it will be available there. Why? Because we don't run primary health center very well. Doctors are absent. If there are beds for the for admitting patients, they are not working because there is no good infrastructure, medicine available. So they don't run primary health. So what happens to these women? They have to go to the district level, which are totally overcrowded. They go to the private, that's how. Again, the government system, confidentiality is not good enough. So women prefer to go to somewhere away from their village to the private sector. They have to pay. Now, if that's what was given to us, given to women, was the civil and political right to abortion, not the economic right to abortion. Economic right to abortion would have meant that it was made accessible within the geographical area that women wanted, and there were no financial barrier for them getting it. Even when they go to the private sector, it should get reimbursed by the state, but it never happened. So it was a partial human rights was granted through the under the tutelage of the medicine. So this is the history. Let me now go into ethical or philosophical arguments, on abortion. These are three major standpoints there. They're just classified. I have borrowed it from a handbook that is brought out by the Hastings Center in New York, which was one of the first bioethics center, which was established in 1970 or 71. 3 categories of them. Conservative, which are pro-life. You always see in the newspaper about pro-life people talking like this. Liberal, pro-choice, and the moderate, which is a compromise. And the law is normally situated on the moderate ethical arguments. So what is conservative argument? The early conservative arguments were all religious. Even today, now with the way things are happening in USA, you can see that there is a resurgence of religion and the religious arguments are coming back. But in 1971, when the abortion was liberalized, they were not the religious argument that they were making. They were making a lot of conservative argument. And they said that, well, fetus is a human being. And if you do an abortion, then you are killing a person. And they demanded that the fetus should be given a status of a person. And so one cannot, one cannot do the abortion. There were more sophisticated arguments based on economic issues, like saying that when you kill somebody that is in the womb, then you are depriving that person of a bright future. That means if the fetus was born, fetus would have lived for, say, whatever average life expectancy in the country and enjoyed that life. You are taking away future of the future generation. And that is not allowed. It's not about killing or anything like that. It is not about, fetus is a person or not. But what you are doing is depriving, and that deprivation in itself is wrong. So there is a whole list of conservative arguments I can provide, which are not based on religion, but they are very, very important to look at. I'm not going into all of them. When I teach this subject, I have a long, and I go into all the papers based on that. But if you have more questions, I will definitely take on that. Coming to the liberal argument, this is a mind game that we use when we are talking about abortion. Here is a case of a famous violinist who is a great musician, or you can have any celebrity. You can have a prime minister, you can have a president or whosoever. And you suddenly get up in the morning and you find that you are connected to that person who is a celebrity whose life is valued by the society. And you are told that that person's life is dependent on you. That person is parasite. It feeds on your blood or whatever, your nourishment comes from your blood, from your body. And because that person is very important, you have to stop everything and keep supporting that person. Right? This is what would you do there? This is the mind game where we ask the student and tell them, will you disconnect yourself from it? Will you say that we'll make sacrifice of your life in order to, nurture this famous personality? What exactly needs to be done? This is a dilemma that we throw up and say that what is the right thing? The liberal position is very clear here, saying that no, the fetus is a parasite on the woman. It's like a tenant. And woman decides whether the tenant stays or not, irrespective of howsoever much love she may have for the fetus. It is her decision because she is the one who is nourishing that fetus. And so her determination cannot be taken away. So that does not mean that liberal position does not accept that fetus is not a human being. It says that yes, it is human, or it is a potential human. It is a potential to become a person also. So in biological sense, they are not denying it, but they deny that you can't give full moral status of a person to the fetus. It's a potential one, but not now. It becomes person only on birth. So there is a whole debate on the personhood in political science, that what is meant by personhood. There are a lot of philosophical issues there, but it's a very, very important point here is that should women be bearing the entire burden of a personhood of the fetus? Even if personhood is granted to the fetus, it does not necessarily give a right to use pregnant mother's body against her wishes. It's another strong argument coming from Judith Thompson. Some people and many women have have argued that, but okay, it's not a moral. I think when I undergo abortion, I feel that I have done some immoral act, but I don't think I did the murder. I don't think I have killed somebody. What I did was that something that was very problematic for my life, I got rid of, and I felt uneasy about it, but that's it, right? Or abortion is justified on the basis of conflict of duty. Very simple, practical aspect that I have many other children, many other commitment in the society at the moment, and at this moment, I cannot have a child. If I have a child, my career will be ruined, my mental health will be ruined, and all kind of stuff that you can talk about. Or my existing children will be deprived of good care. So what is the in-between position? That is we call more moderate position. It is that they are in partial agreement with the conservatives, saying that yes, in the late gestation, the fetus looks virtually identical like a born infant. So perhaps you can give some credence to the fetus as a person. Some credence. How much? Again, it will be an issue that is to be sorted out. Also, partial agreement with the liberals, saying that, well, in the early gestation period, I don't think it is murder. That's what liberals, moderate position will say. Because there's no viability of the fetus. When the fetus comes out at early stage, it won't survive. So what is the balancing point? Balancing point is that at worst stage of gestation, the fetus is viable. And using that, there was a moderate position evolved, in order to find a way out. So early abortions, abortion up to 20, 28 weeks made well acceptable. Thereafter, the viability of fetus increases, survival increases, if a fetus is born. That's why they said no, abortion beyond that point is not acceptable. So most liberal laws embody a socio-political compromise and not based on the women's right to abortion. It's a compromise. It still does not say that yes, woman has this right. So this is a major problem you'll find in most of the laws which are there. I'm talking about the foundations of it. So as you know that the conservative and liberal position, both of them are very much centered on the fetus. One say it is person, another say it is not person. The argument which is taken up by the feminism and the women's movement is that focus should be on the woman and not the fetus. What about the woman? You say that, well, you can debate whether fetus is a person or not. Yes and no, and there may be a lot of ambiguity there. But is there any ambiguity that woman is a person? No, pregnant woman is a person. There's absolutely no ambiguity. So why aren't you looking at her right and her welfare? Her right to make choice about giving or not giving birth to a child. Her right to make a choice as well as to change the choice that is made. That means getting pregnant and saying that now I don't want the pregnancy. Both rights needs to be respected by the society. In addition to that, there is a larger social system argument. But there is a systematic gender discrimination, patriarchal oppression of women, a disempowerment. And in that situation, it is the duty of the state to provide more protection for her autonomy, her self-determination. State should not aid into this oppressive system. That is what progressive states should be doing. So law, if it is passed, should be centered on her and giving her more power, rather than giving power to doctors, giving power to demographers, giving powers to the religious people and that kind of stuff. So that is where what I would call a reproductive rights perspective, which at the moral level, at ethical level, provides strong support to the idea of abortion as a woman's choice. Last 2 slides, and then I'll take questions so that I hope at least 10 to 15 minutes are there. So moderate position being in between position is always unstable. Anywhere, any law that is based on moderate position is unstable because it depends upon which movement becomes stronger. If women's movement against patriarchy is very strong in the society, you will find that the entire balance will tilt in favor of the woman. And that's what that was the situation in 60s and 70s and even till 80s. It's from 90s this thing start changing. You know, conservatism takes roots, and there is more religiosity. So presently in India, 20 to 28 weeks. UK started with 28 weeks from the very beginning. So you see that viability cutoff is there. But as the medical science develops and we say, oh, we can save the child, even if child is say 24 weeks or 26 weeks. So that again starts creating problem. Although if there is an early childbirth, the child may have very underdeveloped system, including nervous systems and all, and child may really suffer in future. So that is a different issue. But science keep making inroad there on that. Not only the science also makes inroad by saying that, well, perhaps fetus can feel pain from certain age of gestation. So that if it feels pain, that means it is behaving like a human. And so again try to bring down the viability. So there is always the viability period. There is always a pressure coming from that. And the rise of political rights, as I say, that this US Supreme Court judgment is a classical example of how judiciary gets colored by the religion. And you know how the judges are appointed in US. There is a whole system issue there, which bypasses the voice on the ground and makes judgment which takes away women's rights. So that is what happened in the recent judgment. We have published 2 editorials on it, so I'm not going to elaborate in it. You can go to an IGME site and you can read Ruth McLean's 2 editorials, one before the judgment came and another after the judgment came. Both of them are published and they are on the website. You can have a look at it. What is happening in India? India, as I said, that although all the religions which are there in India were fundamentally, philosophically, were against abortion. And Manusmriti even gives a very harsh punishment to the woman who undergoes abortion and the doctors who do the abortion. Both of them are punished if you read Manusmriti. And yet, it was very, very liberal on this. But what is happening is that there are more and more doctors as I talk to them. There is no empirical evidence at the moment with me because people have not done research on it. But are doctors in India becoming religious? More and more I'm finding is they are becoming, And as they become religious, they say, well, earlier we did abortion despite our religion saying no. But now there is no demand for the population control. You see, the fertility is coming down in any case without, making any effort. So why should we keep doing abortion? So there is a whole rise of political religion is making effect. On the other hand, there is a whole changing market. Earlier, all abortions were surgical abortion. In the legal abortions were surgical abortion, where the doctor's clinic will be required. And so it was any new obstetric and gynecologist. When he started a clinic, it was a money spinner. It was a bread and butter of the doctor, which changed with the medical abortion coming in, and women getting easy access to medical abortion made doctors' role secondary. And so that way they started losing market. And you'll find that obstetric and gynecologists are more now going in the direction of assisted reproduction. They are going more in doing a lot of gynecological work, including hysterectomies and that kind of stuff. And even maternity, you will find that they are doing more cesarean section in order to make money. This is simply because Indian health system is dominated by the private sector, and the market, things are changed. So on one hand, there is a religion. On the other hand, they don't get enough cases of surgical abortion, and so they find that abortion is not very important for them now. On the other hand, there are activists who have pushed the gestation period for which the abortion should be available beyond 20 weeks. Beyond 20 weeks was the original. Now it goes 24 to 28 weeks with the with the intervention of the medical boards and the courts. And so they are using the whole idea of fetal disability, that if there is a fetus which is having disability in it, a congenital malformation and all kind of stuff, then the woman's health is jeopardized and the fetus will not have a good life. And so they should be given exception, and that should be provided. So that's how the entire thing has expanded, and now it is in the law also incorporated. I don't like this strategy that is used by the activists in support of the abortion. I find that although it is working at the moment, it may not in long term be good for the abortion rights in India. Fetal disability arguments which are used in the court actually still keep the focus on the fetus and not on the woman. And for me, it is very, very important that if you want a qualitatively different empowerment of women, then it should be right of the woman and not because of the fetus is not well, And by another reason is that if you keep too much of focus on the fetus, then it will really work in the hands of the pro-life people, because once when you become very conscious about the fetus, it will go into the pro-life thing. Not only that, more importantly, it really raises several issues for the disability movement. The disability movement today is very strong in India and very progressive to my understanding. It even fights for the disabled people's right to be professional, even doctors. That if you have disability, you can't do medicine. No, that is not. I mean, there are, you read, we have published special issues on ethics and disability, and you will find their articles that showing that in the health system, they are really fighting for it. And they are, by keeping the focus on the fetus disability, what we are doing is that we are saying that, well, there is a family which will be ruined if a disabled fetus is born. Why are we only talking about a single family? The disability movement is doing two things. One thing is saying is that it is the job of the state and the society to ensure that the disabled people can enjoy life as well as anybody else in this country. So if they have to go somewhere, and if they are on the wheelchair, you have to have ramps in every places where they want to go, and they have a right to go anywhere where everybody is going, right? And many other things, where empowering disabled to live their life freely and according to their choice is becoming one major issue, and they are fighting for. They are also fighting for, saying that, well, if there are disabled people and the family are in crisis, the state should be providing services for the disabled. State should be providing support, financial support to those families. So desperation of family is used in order to, buttress at the moment the claim for the late abortion, but that is a temporary phase to my understanding, and we need to go beyond it and again get the focus on the woman's right to abortion. This is the last slide. What are the dilemmas and other challenges at the social and policy level? So as I have already mentioned that it is civil and political right we have got. I think what is more important is to fight for the economic access to abortion. Any kind of a problem and discrimination based on caste and religion in the health system. This is more important than anything else, because otherwise you have a right to abortion, but you may not have money to buy it in the market. And the government system, with the state withdrawing from the supporting it, is becoming worse in day by day, and then you may have a long queue to get what you want. And that's how I think what is required is to fight to extend the right to abortion from civil and political sphere to the social and economic sphere. I already talked about the disability related issues, so I'm not going to go into that. But yes, it is a duty of those who support safe abortion also to support the rights of the disabled to get good public services and support for their families, for the survivor. Again, the issue is that of also use of abortion as a support to the family planning. As we know that people are embarrassing contraceptives on their own, contraceptive measures, and the issue of abortion should not be tagged to family planning, but it should be tagged to the woman's right to have abortion. There are also arguments that abortion is bad simply because that makes women more accessible to men, make men irresponsible. This argument also comes from a section of feminists saying that abortion has played in the hands of men. So they can impregnate women and then get them aborted. And so that way men becomes irresponsible. Maybe there is some validity in the argument. What is important is that if woman is empowered for abortion, we hope that will also lead to women's empowerment in sexuality and sexual relationship. And then this argument can be fought again. Last area is the scientific area. You know about sex selective abortion and the whole debate. I'm not going into that. I'm also not going into assisted reproduction. All of them require a separate session. Right. Ectogenesis is another one which is argued. You know that we have already had some experiment of uterine transplantation. Now this is beyond it. This is creating an artificial womb where fetus can be nurtured and born. That means you don't need a woman's womb to have a reproduction at all. And if a woman gets pregnant and she wants to have abortion, you can have abortion. That means transferring the fetus from woman's womb to the artificial womb. So you have an abortion without fetal death, right? So, but these are all fantastic ideas. There is no actually on the horizon any kind of ectogenic discoveries and the technology is available. But you will find some literature on this subject where people talk about the future, a fantastic future, which may be there, which may not be there. I don't know. We don't know how science will develop and to what extent we'll be able to achieve it. There's also huge development in neurosciences. It's as I said, the pain-capable Unborn Child Protection Act that was passed in Idaho in US, saying that the fetus can feel the pain, and so abortion is not allowed. So the neurosciences, as it develops more and more, it also may cut down, through its discovery, the viability issue. So the viability as a compromise will come under threat as it develops. And so the moderate compromise will get unsettled again, and then there will be more fights there. And there is, as I told you, there is increasing conservatism of doctors, and that is where the conscientious objection, doctors find that if I do abortion, I'll be morally injured, injured or traumatized, because that is against my belief system. And so I should not be asked to do it. And there is a strong movement against it, saying that, well, if you join medicine, then you jolly well do everything that medicine requires you to do. But there is a whole massive literature on this. And conscientious objection is not only related to abortion. It's a broader area, like say, should doctor participate in euthanasia or what we call assisted dying, or withdrawing a life support system. Okay, that is also issue related to the conscience. When many doctors would say that I would not like to do, even if there is a law permitting it. There are also doctors who may say that, well, I will go and participate in the, say, torture of a terrorist because terrorist has an information and I support the government and government is trying to get the information, right? Some will say no because their conscience will say that no, you can't participate in torture. Doctors should not be doing harm to anybody, right? So, or they say that, well, will you provide health care or medical care to an injured terrorist? Some doctors will say yes. That is what doctors should do, irrespective of the background of the patient, whatever social background maybe there, maybe prisoner, maybe terrorist, maybe poor person, rich person. Your job is to treat and treat everybody equally. On the other hand, some will say that no, I will feel reluctant. My conscience. So the conscientious objection is a larger issue. But in the case of abortion, if more and more doctors start getting out of it, the woman's need is denied. And as you know, that the patriarchal ideology is so strong that even when there is a legalized abortion, you may find that there are very few providers to provide it. And that creates a problem. And that's how there is a strong argument to say that there should not be any conscientious objection. If that is legal, if that is approved by the society, then all doctors should be doing it. So I just finish it. If you have questions, I will take them, and let me stop sharing us.
There are 6 questions. You can see in the question box.
Okay, let me.
If someone want to speak, then they can raise hand also.
Yeah.
Yeah, it will be good if you speak, Arya. Have I stopped sharing or not stopped sharing?
Not yet, sir. Please try again. If any person want to
okay, done.
speak, they can raise hand.
Binita Behra and Ipshita Mitra. They have asked questions.
Binita ji,
Okay. Yes. So, sir, very good evening and thank you for the session. It was very educative. So, I have worked on the issue of sex-selective abortion. In fact, with one of the speakers, Professor Vijayalakshmi Nanda, so in NCR and North India. So my thing is, I can just ask you both the questions that I put in the Q&A. Number one is, if you look at the MTP Act, one main ground is it looks as if, it is basically to make room for the fact that if a woman is facing sexual violence, say rape or something, and she becomes pregnant, and so it can be taken care of in that case, abortion becomes a very humane kind of way for her. So that is one. And the number two thing is that considering that abortion, MTP has always, like especially people who worked very closely on sex selective abortions issue, we do understand that MTP has really, been responsible for the onset of you can say a slew of when the ultrasound was introduced, when it became very easily available in different regions of India. So MTP was the key act because of which people could, sort of go ahead and make these sex selective abortions.
Oh, well, hi, Vinita. Thank you for the questions. Let me quickly answer both of them. The first thing is that the Act, MTP Act, Medical Termination of Pregnancy Act, is not only for the sexual violence, but it's for the pregnancy of any kind. A pregnancy
Yes.
out of love is also covered there if a woman feels that having child is going to create economic and psychological problems for her, or if
Yes,
there was a use of contraceptives and it failed, it's also covered there. So there are list of the sexual violence is also one of them. So there are conditions on which the medical termination of pregnancy is allowed in the country. And my argument is that there should not be any condition. Okay, that is what's my fundamental philosophical argument, and which is that the abortion should be treated as a woman's inseparable right, and it is only she decides whether to have a child or not to have a child. No condition should be asked for. Even if she has not faced sexual violence, even if she has no economic problem, even if she is psychologically all right, but she does not want a child there at that moment, she should be given this right. So I'm much ahead of it. It's not only about that. The second thing is I wrote long back in 1980s. The whole movement against sex determination started in Mumbai. I come from there, and at that time we were very careful not to use the term sex selection. We say that what is most important here are the technologies that can help to find out the sex of the fetus, and then lead to the abortion if the fetus is a woman. And so we wanted the regulation only of that. We said that hands off MTPI. Don't change anything in the MTPI, because if you change anything there, then you are going to take away the right of woman to have abortion. And if right is taken away, the historical evidence show that any country where abortion is made criminal, the woman continues to have abortion, but in a very, very bad way. And that way, it is very, very detrimental to the woman. So in order to save woman, a fetus woman, we cannot sacrifice the womanhood in general, right? So it's not, woman does not gain there, by saying that, well, you mentioned that women should not have undergone any kind of sex determination. Unfortunately, in India, the misguided activists, particularly those activists who did not care for the abortion rights and safety of the abortion, they linked these things up, and they ensured that the sex determination, the struggle against for the regulation of the sex determination technology was converted into the struggle against sex selection, right? And that's what's my position, and I still hold it. And I believe that whatever may happen in the sex selection, the abortion as a right should not be touched upon, because that is going to be equally detrimental to the woman as the sex selective abortions are. What is the second one? Ishpita?
Yes, sir.
Ishpita, yeah.
Ipshita, do you have, but Ipshita is saying that she doesn't have a question. Okay.
Absolutely. So somewhere there has been a lack of steam in terms of collective dissent and resistance with the atmosphere which is governed by fear and surveillance. Perspective on issues are shaky today. That is what I feel. There is religious fundamentalism, there are kangaroo courts and dismissal of subjectivities and embodied reality. So there is a lot of...
Hello, am I audible?
Yeah, I read your stuff.
Ipshita, go ahead.
Yeah, so sorry. Sorry, sir. This question was actually directed at Dr. Albertina. We were discussing the Bilkis Bano case. But, but coming to your session, it was absolutely insightful and enlightening. So thank you so much for this wonderful session. I wanted to ask you about conscientious objection, that you said that how it can be extended to the debate of euthanasia as well. And how there is a moral consciousness working when doctors are asked to treat, let's say, terrorists, etc. But I'm not able to see how this can be compared to a woman's right to abortion and her right to a doctor assisting her in that. So if you could elaborate a bit on that,
Well, it's very simple that conscientious objection is used in many countries by the doctors to excuse themselves from doing abortion on the women. And not only that, there are not only doctors, but even nurses will say that will not participate. And the chemist will say that I will not dispense a drug if it is going to cause abortion. Not only that, the countries where the religiosity is very high, particularly Christian religiosity, they will also not allow contraception. So the even pharmacist will not dispense contraceptive, even if I write a prescription for it. Now this is a major issue. So if a society like India, if there are more and more doctors think that abortion is a dirty work, and that's, I think, when I meet the doctors, many times they say it's easy work, but it's also not the work that they would like. And if that kind of things happen, and out of the religious position, that my religion says that, well, don't do abortion. So now I am a very religious person, and because of that, I don't want to conduct abortion, and more doctors get out of it. On the other hand, if there are extremists, fundamentalist religious people, they have not happened in India, but it has happened in other countries. Particularly you can say in Latin American countries and developed countries, where they have attacked the doctors who provide abortion. So you'll find that even USA, after 1971 Supreme Court judgment, the abortion was made legal. But the providers, number of providers available were very few. And those who were trying to provide, they will be attacked. There are doctors who have died because they were killed by this kind of attacks. What was there? They were providing abortion services, which was legal in that country, and still they were attacked. Simply because, well, the state may become progressive on something, but the civil society has an extremist who says that it should not be done. So this is an issue where the whole thing comes up, conscientious objection. That whole idea that if I am made to do something which is demand of my client, then it will cause injury to my conscience, injury to my moral sense. That is, I was first time introduced to the term moral injury. I never thought of it in 70s and 80s when I was studying medicine, and 80s when I was doing a lot of research, 80s and 90s. I had never heard of this term. It's only when I started reading literature on conscientious objection that I encountered this term. It is nothing but saying that a doctor, because of the legal environment or the demand of the health system, is required to do something which he or she morally considered to be wrong. Abortion is only one example. As I said that, well, it can be assisted death. It can be withdrawal of life support system. Many doctors will consider that to be wrong, although the patient and patient relatives have gone and made the request as per the legal requirement and regulatory requirement. And still, doctor may not like to do it simply because he says or she says that I'll be morally injured. So that is what conscientious objection does, and it takes away the number of providers, and that takes away women's right to receive the critical reproductive health services for abortion. So this is an issue which is actually, I normally have a separate lecture on conscientious abortion, conscientious objection, because there also you have three different positions. One is saying that the conscientious objection should be supreme, that should govern a doctor's behavior. The other will say conscientious objection is completely a facade, of the doctors. It's a kind of an excuse where the real issues are very, very different, and they should not have any right of doing that. And then there are people who are in middle saying that, well, if there is another doctor available whom you know and who does the abortion, you should refer the woman to that person and ensure that she gets abortion. But because you don't believe it, you will not do it. Right. Those who take conscientious objection, they will even argue that even showing them the road, saying that go in that direction where you will get abortion, is against my morality. So extreme morality cannot be easily satisfied. So that's where the debate on the conscientious objection lies at the moment.
Thank you, sir.
Megha ji is here. Megha ji.
Yes.
Kindly be brief.
Yes. Thank you so much. Very informative session, sir. I just wanted to understand the perspective or stance on abortion when it comes to surrogacy pregnancy? Do we have any inkling on how that proceeds?
Well, that is the major problem. In the surrogacy contracts as they are and the law as it stands, the woman who agrees to be surrogate gives up the right to have abortion, and that's I don't like. It's like the entire pregnancy is controlled by the commissioning parents or commissioning person or persons or couple, whatever they are, At the moment, they are not allowed in India. Only married couples are allowed to have surrogates. But the law is very regressive there. I don't agree with the current law. I find it is ethically and legally, and from the perspective of human rights, problematic, and it violates the rights of the non-binary sexual and gender people, their right to have their own children. But the present law does not provide that right to the surrogate mother. Not only that, it also now makes it legal that she has to surrender the child. That means after child is born, and woman wants to change mind and say that, now I don't think I would like to give this child away to you because I am a gestational mother. In this entire surrogacy business and assisted reproduction, what is supreme is not the biology and not the woman who carries the child. What is supreme is whose genes are there. This genetic determinism, which can also be called biological determinism, that the commissioning people, it can also be called market determinism. The commissioning people, who are the most powerful, and that is the problem. I believe that surrogate mother who is volunteering to have a surrogate pregnancy should not be made to surrender all her rights as it is being done today. If she wants to have abortion at some stage for whatever reason, she should be allowed. That means the commissioning people have to go for another surrogate, another hardship. But in order to protect this commissioning people, you cannot exploit and violate the self-determination of the woman who has agreed to do a service for you. I think that's what I believe, and that's what's my strong position. I can argue out and explain more in elaboration, but that is some other day. I hope there will be another session on assisted reproduction or surrogacy, then we can do it.
Thank you so much, sir. Thank you.
Now we would like to move on to our next speaker for today.
Okay, thank you. Bye-bye. Yeah.
Thank you so much, sir. Thank you so much for your time.
You can answer Brithika's question in the question box. She has asked about medical tourism and abortion. As so many countries have outlawed abortion, will the people, India become the destination for abortion? And India will on foreign exchange. So just answer that in question box. Sorry. Yeah.
Thank you, ma'am. We'd really appreciate that, sir, if you could put that up in the question box. Thank you. Next up, we have Advocate Dr. Shalu Nigam, advocate, author, and researcher, gender and human rights. Please take it from here. Thank you. Shalu, ma'am, are you here?
Yeah, she's muted. Her video.
Yeah.
Yes.
So there is something that's not working. You can mind. Yeah, so good evening to all of you. Am I visible?
Yes, ma'am, your camera is off. The screen share is perfect.
Yeah, I'll just start my video.
Now it's working. Yes, please go ahead.
So good evening to all of you. We have two very good presentations right now, and I know that we are running late, and someone has also raised about the issue of Bilkis Bano, and there are a lot of other cases. But what I will talk today about is everyday violence, because those cases are comes into special category. So I will just today I'll talk about right now what is happening in the courts and how the conservative patriarchal family ideology operate and is being challenged in the court. So my presentation is divided into two parts. In part one, I'll talk about the domestic violence law, the very basic part, and in second part, it is about how the ideology operates in the court, the family ideology. So what is domestic violence? Domestic violence is centered on three key elements. Violence that is continuous, from which there is no escape, and it is different from violence by the strangers. Then second element is domesticity, which include both the location and the relationship between the abuse and the victim. And third is about the structural inequality, which work through the paradigm of power and control. So I have divided it into 7 dimensions of powerlessness in the relationship. First is that domestic violence takes place within the confines of home, a home which is assumingly a place of comfort and security and an escape from the outside world. Second, the abuser and the victim, they share special kind of relationship. So abuser is a kind of protector and provider. Third, an unequal relationship exists between the abuser and the victim because of emotional, material, and economic dependence of women on her abuser. Fourth, relationship in which violence takes place is not dyadic. As in Western countries, we have just men and women. Here we are talking about other family members also getting involved. Fifth, the volatility of the situation enhances because the relationship is adorned with the notion of intimacy, romanticism, and sexuality. So, any kind of hurt, it has much drastic impact. Sixth is that patrilineal and patrilocal arrangements, add to the disadvantage of women, because they isolate her and put her in the lowest position within the hierarchy of the family. So, and seventh is that the culture of patriarchy and culture of violence coexist and operate in a manner to deny women of their rightful entitlements. So, international framework on violence against women, they have recognized domestic violence as a violation of human rights. In the UN World Conference in Mexico in 1975, this was raised as an important issue. And in CETA 1979, the states are, it says that states are required to take legislative measures. In Nairobi 1985 conference, the issue of gender-based violence was construed as a hindrance to the goal of human rights and peace. In 1991, it was recommended that international instrument on violence against women should be made, and an expert group was subsequently formulated. In 1993, the UN General Assembly adopted Declaration on Violence Against Women. In 1994, the Special Rapporteur on Violence Against Women was established. And in UN Fourth World Conference in Beijing in 1995, 180 governments agreed that violence against women is a critical issue. So in 1996, framework for model legislation on domestic violence was enacted. This framework called on countries to comply with international standards prescribing domestic violence as gender-specific violence, and since then guidelines are formed to enact a legislation in numerous countries. Now, this framework defined essential components of legislation such as complaint mechanisms, duty of judicial officers, criminal and civil proceedings, and provision for various services. It calls for speedy remedies and effective enforcement to provide relief and to prevent further abuse. Other non-legal measures, which the states should take is, it includes capacity building for law implementers and service providers, awareness raising, education, and action towards a comprehensive response. In India, if we talk about domestic violence and legal reform, we all know that during the decade of 1980s, a lot of women were dying because of stroke deaths. And then we have the ruthless killing of Shashi Bala, Darvinder Kaur, Kanchan Chopra, Sudha Goyal, and all these cases, they become the rally point to reform. And then we have Section 498A and Section 304B that were introduced in the Indian Penal Code. Section 498A talks about cruelty within the matrimonial home, which women face, and it provides for 3 years of punishment for the husband and the in-laws, and 304B is about the dowry death if women die within the special circumstances within the matrimonial home. So the Family Court Act was enacted in 1984 as a specialized forum to deal with the matrimonial conflict. Again, it is not domestic violence, but conflicts is the major term they have been using. The Domestic Violence Act, PWDVA, that was enacted in 2005 to ensure that the concerns that women face once they file the complaint to the 498A would be addressed. Now, what was happening was that once women file a complaint under 498A, she's being thrown out of the house, the custody of children is being taken by the husband. So a lot of problems were there, because of which Domestic Violence Act was enacted in 2005. This law provides for effective protection of the rights of women guaranteed under the Constitution. So this law is gender specific, and it allows women to seek injunctions in the forms of order and breaches of such orders, and it ensures relief that are time bound. Theoretically, this law has been appreciated for its compliance with the UN framework for model legislation we have seen in the previous slide, and it is seen as one of the progressive law. So this act recognized relationship beyond marriage and broadened the concept of domestic relationship to include all kinds of relationships based on marriage, adoption, and other relationships which are in the nature of marriage. It provides the remedies to all women in abusive relationship, including those in fraudulent marriage or invalid marriage. It also protects the rights of unmarried women, siblings, widow, and other women living with the abuser. The Act introduced multidisciplinary personnel to assist women, such as protection officers and service providers. The Act defined domestic violence as an act of gender-based violence and include not only physical violence, but also verbal, mental, emotional, psychological, and all other forms of violence. And it provides reliefs and remedies in terms of protection orders, residence orders, custody orders, maintenance orders, and so on. For women, the law implies empowerment and escape from the situation of vulnerability, but obviously men don't like it, as we see in the coming slides. So the objective of domestic violence law is to act as a double-edged sword. It controls and monitor and deter the abuse. The law is enacted with the goal to attack unequal and unjust norms. The objective of law is to seek the rights and balance the power equation, which is very unequal. So the larger aim is to promote a culture that promotes constitutional values. So, but what is happening in the court when I went to the courts in Delhi and I talked to the survivors of the violence who are coming to the courts, and what we saw is that the purpose of law is lost behind the technicalities. And even if you see the judgments, a lot of subjectivity is involved in translating and interpreting the law. So at various levels, at the level of police, at the level of judiciary, a lot of subjectivities are being involved when it comes to implementation of law. So in part 2, we will look at how the family ideology operates within the court. Now, this is again divided into 3 parts. In part 1, I'll talk about the NCRB data, which shows that number of women in 2018, 2019, and 2020, more than 1 lakh women are filing cases under 498A, that is cruelty within the matrimonial home. Now, these women are approaching the legal system as agent of change, and they hope that they no longer will be abused. The complainants do not see their violent husband as lords or master, but they're expecting men to be their partners and companions. This changing aspiration of young women is also reflected in some of the latest movies which have been made on the issue of domestic violence, such as Darling, Secret, Superstar, and so on. Now, what these women are demanding when they are coming to the court is a violence-free home. They see marriage as companionship and partnership. And these complainants do not see their violent husband as, lords or master, but they're expecting men to be their partners and companions. But however, on the other side, what is happening is that the violent men, the male-dominated courts, and the patriarchal society, which I am calling them as preservers and upkeepers of patriarchy, they are not willing to come out of their traditional age-old conservative mindset. This rigid conservative attitude of the court is evident in one of the recent remarks made by a Delhi High Court judge who hailed Manusmriti and preached about family ideology rather than endorsing the constitutional values. So also in other, a lot of judgments, if you analyze, you will see that the courts promote familyism and not feminism. The patriarchal logic in such decisions paint the complainant, the women who are going to the courts, as disgruntled women, lawyers, the gold diggers, and so on. So despite the fact that law says that the rights of the victims and survivors should be protected. So what is happening is, I'm calling this as a clash of ideology that operate every day within the courtroom. Now, this work shows that in the 21st century, a vast difference exists between the way women on grounds are dealing with the realities of domestic abuse, the way domestic violence laws exist on paper, and the top-down approach taken by the courts while implementing the law. So I also want to show that insecurity prevails in the patriarchal society. When new generation of women are coming to the courts and demanding violence-free homes. So they see marriage as a partnership, not as a sacrament. It also shows that how violent men in patriarchal courts both have failed, to keep pace with the changing aspirations of women. So this is the kind of diagrammatic representation which I have just tried to, show that that women here are, as agent of change. They are coming in large number. They are approaching the legal system with the hope that they will no longer be abused in their marital homes. So these women are questioning the abusive power of violent husband, whereas the violent men, the male-dominated courts and patriarchal society, as the preservers of patriarchy or traditions and sanskar, they are promoting rigid, conservative, patriarchal mindset. So the courts are promoting family ideology, whereas the women are demanding non-violent kind of environment. So there is a clash of ideology that is taking place in the courts, and the courts are giving misogynist injustice, which in turn affect the position of women. So what we need to do here is that we have to empower women who are coming to the courts, and on the second side, we also have to work with the ideological position which is taken by men, the courts, and the society. So this is what I will, explain in detail here. Now, first of all, I would take you to this website of Delhi family courts. So it says that happy families lives together. Now, it never says that happy family does not tolerate violence against women and children, or that happy family is a democratic family, or that happy family promotes love and equality, or that if, the happy family guarantees safety and security to each of its members. What it says is that happy family lives together, but at what cost, the family live together, and who is paying that cost, that we have to look into. So how the courts are promoting conservatism is that on 10th of August, a conference was organized. The topic was facing the unseen barriers, addressing challenges faced by women in science, technology, entrepreneurship, and mathematics. Now, in this conference, a Delhi High Court judge, she says that Indian women are a blessed lot, since Indian culture and scriptures like Manusmriti gives a very respectable position to women. And she further goes on to state that sharing is caring, and the joint family system is beneficial, and so on. So these critiques, these remarks of hailing Manusmriti and conserving joint families draw severe disapproval and critiqued by activists, scholars, civil society organizations, and social media. And it is being said that this approach is scary, patriarchal, it legitimizes conservative norms, institutionalized gender role, and goes against the grain of constitutional values. So, but however, this is not for the first time that judges have upheld the conservative patriarchal ideology that view women as second-class citizens. These anti-women decisions have hailed men as masters and lord in marriage, despite of constitutional guarantees. For instance, I'll just quote a quote from the Kerala, what the Kerala court has said, that a wife should be administrated in purpose, slave in bed, beautiful in appearance, earth in patience, mother in love, and prostitute in bed. Now, this he is quoting a Sanskrit shloka to interpret the duty of women in the matrimonial relationship. Now, again, the courts are quoting the duty of women and not men in the matrimonial relationship. So marriage itself is being seen as a dharmic institution, which is made on heaven and broken on earth, and not as partnership or a companionship. The courts have refused to apply the constitutional values in the domain of family. For instance, Delhi High Court, in one of the very famous judgment, it talks about that constitutional values shouldn't be applied in the home. It is like introducing a bull in a china shop, and it will weaken the marriage institution. And so all this they're talking about in their judgments. The way the domestic violence courts are being decided in the courts are that they grant immunity to a violent husband and protect the relation of domination in the garb of love and discipline. For instance, there are cases where court opine that in case a wife is forgetful or is devoid of etiquette and courtesy, her husband has right to beat her. Similarly, in another case, the court has held if wife is not performing her obligations, the husband can seek divorce on the grounds of cruelty. In yet another case, divorce is granted because wife is taunting the husband for being overweight. So human subjectivity is poured in while interpreting the facts and circumstances of the case, and any grievance is viewed as a man versus a woman's issues rather than as a patriarchal or structural problem. So in many cases, the court have construed wives as the image of perfect wife. So if the court have said that if a woman is refusing to make food and serve it to husband or his relatives, or if she refused to wear traditional symbols such as Mangal Sutra or Sindoor, she is perceived as a bad wife. So there are cases where a woman are being seen as a bad wife if she has refused to wear a Mangal Sutra or Sindoor, and it is seen as her unwillingness to continue the conjugal life, and it amounts to cruelty on the basis of which a husband can obtain divorce. In one of the case, a wife was found guilty because she refused to cook the food and to serve the meal to the husband and the member of his family, and used to move out without any permission. But the wife said that her husband was harassing her for 50,000 rupees as dowry. So, again, how the courts are interpreting, the facts that we have to see. In another case, a wife is granted decree of divorce because the court felt that wife's unwillingness to have a biological child is a cruel behavior. In another case, very famous case, separating a husband from his family, it's amount, the court says that it amounts to cruelty. Now the court is not seeing that a woman in patriarchal society is leaving her home and joining her husband's home. So this is how subjectivities are being interpreted in the courts. In many cases, the courts have said that you know, you dilute the provision of Section 498A and make it compoundable. Compoundable meaning, you know, both the parties can say that, okay, we are agreeing to take back this, withdraw the petition. In Sushil Kumar Sharma versus Union of India, the court says that by the misuse of provision of 498A, a new legal terrorism can be unleashed. In many other cases, the courts have directed police to take precautions while filing FIRs, making arrest or granting bail. Now, again, serious complaints of violence are being normalized while dubbing as dispute. Generalized assumptions regarding the misuse of laws are being made, and no efforts are being made to call upon the records of other public bodies such as NCW, National Family Health Survey data, or ministries for documenting the data on women issues. So subjective assertions are being made in the courts because perhaps the law is threatening the power equation. In a very famous case in 2014, the court issued guidelines that you know, the Section 498A should be made cognizable and non-bailable because women are using it as a weapon, you know, as disgruntled wives. And the court made this observation that in quite a number of cases, bedridden grandfathers, mothers and the sisters living abroad are being arrested. Now, this assertion is being made without looking at the data from the prison. I look at the data from the prison, and it says that very few, you know, 0.01% prisoners in the hard jail are there for, you know, under 498A or even for the dowry law, that there are very less number of people. So the courts are not looking into the data on prison, you know, on the hard jail or, you know, any other form of prisons. But simple, you know, assertions are being made and repeated again and again. So in another case in 2017, the court passed the directive and you know, it says that to constitute a family welfare committee in every district to scrutinize every complaint of violence, because vengeful women are, you know, misusing the law, and the court see men as victim of this cruel law. So after this women's group protested, these directions were modified in 2018. Some of these directions are modified, but generally the directions relating to bail and arrest are being kept within the law. So, but these assertions are being made again and again without looking at the data that women are using law as a weapon, you know, as disgruntled wives. Now, again, the court are mostly comprising of men as judges and lawyers. You know, they use masculine lens to filter the complaints of women. You know, this masculinity is so fragile that, for instance, in one case, the husband filed a defamation suit against the wife because in her pleadings she has used the word important for him. The magistrate found that, you know, this case is being made out, and he issued the process, and this is being challenged by the wife in the High Court. The High Court observed that prima facie the word important, when understood in plain sense, it reflects adversely upon the manhood of a person. So the scars on women's bodies are not being taken so seriously as this one word being used in the petition by the wife. So this is the way that the, you know, subjectivities are you know, are being operated within the courtrooms. In another case, the court says that the wife should undergo DNA test to establish that she is not unfaithful, adulterous, or disloyal. Again, for men, there are no such you know, comments being made that they should also go some test to prove that they are faithful or loyal in the relationship. In several cases, the law is interpreted to deter the complainants from raising their voice, and filing a case under 498A itself is considered as an act of cruelty. For instance, a Karnataka High Court, while quashing the complaint made by the wife, asked her to pay the cost of 25,000 to ex-husband for abusing the process of law because she filed a complaint under 498A. The court says that the petitioner man has suffered because the woman has filed the complaint. So the women who raise complaints are not seen as citizens demanding protection from their abusive husbands. In many of the cases, the courts, they have rejected the complaints filed by women and they construed that as an act of cruelty. So gender stereotypes dictate and influence the bureaucratic action. So Law Commission in its various reports, 154th report, 237th report, and 243rd report, they have suggested that domestic violence law be made compoundable. Again, the Ministry of Home Affairs has issued strict advisories over the years in terms of, to avoid unnecessary arrest in 498A cases and to curtail the misuse of law. The Ministry and the NCW have also, again, at various points, they have spoken about providing a window for men, and that men are being falsely implicated in domestic violence cases. So this, with the patriarchal domination, has guided the action of various actors within the institution. So this is what I've termed as misogynist injustice, where the system, instead of facilitating the access of justice, is creating a hindrance and is interpreting the affirmative law in an adverse manner. As if the implementers of the rule of the law, the courts are duty bound to apply the law as per the constitutional provision, but this is not happening. And what is happening is that the stereotypes and the myth are frequently reflected in the verdicts. So again, domestic violence is seen as a man versus a woman issue, rather than as a system of patriarchy or structural indiscrimination. Also, the courts have failed to draw a distinction between the serious violence and the disputes. So the law is being manipulated to use the misogynist filter. I call this as a process of patriarchal manipulation that is negating the complaints of women and while abandoning the ideas of basic principles of law. And this leads to misogynist injustice. But what is happening on the other hand, that Indian women are no longer seeking lords and masters. So if you see several of the movies which have come in the past several years, like Secret Superstar, Saath Hunma, Queen Provoke, so many other movies which are away from the stereotypical image of women as Sita or Savitri. These movies illustrate the changing aspiration of women and demonstrate that that there is a desire to shatter this idea of seeing men in the superior position. The content depicted in these movies are not very different from the existing ground realities. Women are facing abuse in homes in various forms and are dealing it in different ways. So they are, fighting against a stubborn patriarchy, not as helpless or bechare victim, but as a normal human beings. This is despite the fact that conviction rate in domestic violence cases remain very low. It is 13% in 2021, and it's less, even less in previous years. So journey to justice is not easy for women. We have seen from National Family Health Survey data that many of women and men agree that it is justifiable for a husband to beat the wife. There are studies which report that only 1 out of 1,000 victims air their grievances, and minimum period for which women suffer before making a complaint is 3 years. Yet those women who are pushing the violence in marriage, it is through their sheer grit are breaking the code of silence to reclaim ownership of their lives, and in the process, they are shaking the system, forcing it to respond. This depicts transformation in the attitude of women. So on the one hand, when legal system re-victimizes the complainants, yet the women are using law as a platform to reclaim their rights and to resist violence in homes. The court compelled women to adjust in violent relationship without any guarantee of safety and security. The male-dominated system, including the police and courts, perhaps have failed to accept the reality that women today are, not living in 2000 years back kind of a thing. So these women are finding courage to register their complaints and are negotiating for their rights and are challenging the stubborn patriarchy. These complainants are not expert in feminism, but with their own sense of justice and with little or no available supports, are seeking violence-free life for their self and for their children. In the courts, women are fighting long battles, not only against abusive men, but also against patriarchy within homes, misogyny in the courts, androcentric culture that prevails in the society, and the sexism and all kind of things we are fighting against. And in doing so, women are transforming the culture of patriarchy. But the abusive men, the patriarchal society and male-dominated courts, they are not ready to come out of their age-old mindset, and this is leading to clash of ideologies, and kind of insecurity prevails in the society, which is fearful of new generation of women who are demanding violence-free homes. So what should the court do? The court should have uphold the constitutional values, which is not happening. Now, Nancy Fraser has spoken about travel dimension of justice to conceptualize economic, social, cultural, and political injustice. While adapting a similar model, I suggest that the concept of justice needs to be applied in broader dimension, and the domination of privileged men couldn't prevail. The need is to overcome not just the gender gap, but to overcome the power gap. Again, the Wendy Brown, she has insisted that sharing of power should be there in true affirmation of democracy, which could end marginalization of women within the families. So again, the courts have to accept this fact that those approaching the system with the complaints of violence are seeking justice as citizens, and the courts are not the khap panchayats who will uphold the customs and tradition. They're supposed to uphold the constitutional values. So this work recommended there is a need to create a space where women are treated not as moral subjects, but as citizens vested with rights. So with this, I will end my presentation. And again, this is the kind of the basic summary of what I have spoken about. And any questions there, if are there, can take that.
There are 4 questions for you.
Yeah.
Anandita Shankar, Radhika Shetty, Vinita Behra. Yeah, 3 of
you. Ma'am, this is Anandita Shankar. Ma'am, am I audible?
Yes, sir.
Yeah. Thank you so much for insightful session, ma'am. My question is related to, it's a general one. So, ma'am, many a times the police actually does not register a domestic violence case or log any formal FIR, and often ask the family to compromise. So in those cases, what are the legal options available to the victim? And is there any way that we can avoid the police route and go have some option of grievance mechanism avoiding the police?
Yeah. If you see that there are various institutions which are being made, such as National Commission of Women, the state commissions which are taking up the cases of domestic violence. And also, if the police is not registering the FIR, a woman can directly go to the magistrate court under Section 200. She can file an application, and the courts will then direct the police to file her FIR. So the thing is that the provisions are there, the legal provisions are there, but the issue which I have been raising is that how the police and the judges are misinterpreting the law, or sometimes forcing a woman to compromise the case. This is the major problem, that they are bringing their own subjectivities instead of following the legal procedure. So this is what we have to challenge. And surely, but in case a woman's complaint is not being filed, she can certainly go to the magistrate and make an application directly over there. and the magistrate can direct the police to take appropriate actions.
Thank you, ma'am.
Ma'am, can I speak?
Yeah.
Yeah, hi, ma'am. So I wanted to say that most of the legal things which are like now discussed in this fora, they're not actually practiced in real. For example, like I went seeking police protection. My friend, she's a CA and I'm pursuing PhD. We were counseled by the police saying that education spoiled you, because of which you have ruined your marital life or something. And we were subjected to a lot of harassment just because of the educational whatever degrees that we have. Second thing is that recently, as a single mother, when I approached say passport office and police 6 years back, the law was amended, like easing the way for single parents. But then I was told by police that, you know, what if you run away with the child? Actually, I had applied because I had an international conference to attend, so I had to attend in 3 countries, leaving my child behind. And I felt very unfortunate because professionally, these are the commitments. And I was told that, what if you run away? What if your husband files a case on us? We are very scared. And, you know, I was treated as if, you know, I was subjected to a lot. I mean, I wouldn't really get into the details, but I just felt, why is it that the grassroots don't follow what is actually, you know, told by the courts? And yeah, ma'am, yeah.
No, please continue.
So the thing is, I mean, the 2 sessions today, one is at workplace and one is at home. I had to unfortunately undergo both, and I'm from a very reputed institute. And like I was told that, you know, my neighbor was troubling me, like he used to stand at my, window and all that. And then when I actually gave complaint, I mean, I stood up for myself, and I was told that you are a student and he's a permanent employee, and at the max we can just transfer him. So they gave him that kind of you know, support in the institute, which is like very unfortunate. And usually, I mean, yesterday also I asked this question about what about the women in academia, because I had to really see the hard side of it. I mean, I wouldn't really take a, I wouldn't say that it's a bad world or something, but I just felt it could be a little more, you know, sensitive towards say the women needs, because I kind of, just because I stood up. And second thing, ma'am, with regard to how a victim should be, I don't think the society should decide, right? I mean, there is no body language, or there is no certain, say, the mental construct which she should exhibit. Because I didn't expect all of that. And people said that we doubt if you really went through these. So if the education is giving you such empowerment, I mean, I do not understand why you should adhere to some victim, you know, norms. Yeah, this is my question.
Yeah, so I'm very sorry for the experience you have, but you know, this is what are I think that the issues most of the women are facing. Like most of us are, you know, fighting for that because you know we have made beautiful laws on paper. The domestic violence law, the sexual harassment of women at workplace law. These laws are very beautiful and very good on paper, and you know a lot of struggle has gone, as you know, by the women's movement. They have taken a lot of pains, fighting for the rights and you know getting these laws. But then what is happening is that again these are not being implemented by the people who should be you know, implementing the law. So initially, if you remember me, you know, within the women's movement, there was discussion and with this National Commission for Women, and you know, the entire that commissions were constituted to ensure that law will be monitored and you know everything. But again, these commissions are being politicized. So again, you know, they are not working as being visualized or imagined then. And similarly, you know, initially there were a lot of discussions that, you know, the police should be educated, the judges, we should work on gender sensitization programs and, you know, all kind of programs. But again, I don't know what happened within past few years that we have stopped doing that. And I don't know how many gender sensitization programs are being taking, you know, place with the police, and how much you know training is being given to judges. You know, all those kind of things we have spoken about earlier are not happening. So in this situation, what can we do? Should we, you know, as we form a victim solidarity survivors, or solidarity networks, or some kind of things to revive all those things, and to ensure that not only that the women are being the legal literacy programs or legal awareness programs, but also again in this direction also, that how to make the court staff, the police, and all those infrastructure be more gender sensitive. So that is one thing I think we need to really discuss.
One more thing, domestic violence isn't always about say physical violence. It could be mental abuse also, right? So how, I mean, when you go to a police station, they would ask, okay, where is the mark, where is the blood? I mean, there were many times like I had to accompany some of my friends also, where it is a lot of say mental abuse. So how would you prove it? I mean, that also is like I mean, that is also domestic violence by all means. But the police often say that where are the visible marks of violence? So I think they should be, I think, sensitized on that also, right?
Yeah, sure, definitely. They should be sensitized, like, that domestic violence is defined more broadly to include mental violence, emotional violence, verbal violence, all sorts of violence. Now, again, that is the major problem, the way the law is being written on papers and the way it is being implemented on the ground. And, that kind of patriarchal ideology or that family ideology which is there, that, okay, you have to save the family, forget about women, whatever, like, send her back to the back to home, even if it is like, violent home, and there is no guarantee of safety or security. So, why the courts are sending women back to home? That is my, my major, dilemma. How should we resolve that? Can we really, and even if the judges are talking about, healing Manusmriti and all, is there a solution to that? I think we all need to think about it, that, how should we counter that ideology? Because we have laws on paper, we have a very good constitution which talks about equality, but what is happening on the ground is something which is very different from what is being written on paper. So how should we, reduce this gap? This is, I think we need to think more about this and work on that.
Yes, ma'am, definitely.
We
Thank
have
you.
we have a
Can-
lot of hands. Okay,
can I-
Binitaji, go ahead. Yeah, Binitaji.
So, ma'am, thank you for your session. But I think I wish the entire judiciary would be like you. Unfortunately, even many of the women who are in the judiciary, they may not be able to have this kind of sensitivity like you have. That's one thing. And secondly, because I have also been in the civil society sector, and I have worked a lot on advocacy on these issues, particularly on domestic violence, but related issues of women. And one thing is we do talk about working with men, but really, I mean, I really don't know, ma'am, how much of it really works, working with men and actually sensitizing them. So my comment also accompanying my question is that, like, I mean, is it only the movies which are supposed to sensitize us, or is it something more? I mean, how can we, sometimes I think that, I mean, I'm a sociologist and I've been really wanting to study law for I don't know how many years. And is it that everyone should have basic knowledge of law, etc., right from the school times, or what would you suggest?
Shalom, ma'am, can we take some more questions so that we'll save some time? Right?
Okay, and
Okay.
And another thing is my second connected question is I teach sociology to law students, so I would like your suggestions on some good suggestions on how to make the law students more sensitive to these issues, because they always go by the case laws, and as you have given a critical analysis of the case laws. But generally, I mean, if you look at the classroom scenario, there's always an argument. It's always become the male students versus the female students, and sometimes it's not conclusive also. So I would really like your opinion on this and some suggestions.
Right, Radhika Shetty ji, please kindly be brief. Yeah.
Sorry, no
Please.
questions on my end. Thank you so much.
Okay, Prakash ji. Prakash Almeida ji. Okay. Kuldeep Kaur ji, do you have anything to say? You can unmute yourself.
Yes, hi, good evening, everyone. Ma'am, my question is, I personally face two situations as a head of the institution when directly I approached to the police about a cyber crime. Being as a principal, I'm having many students in my campus, and still indirectly I got the message after 2 months that I have already withdrawn my case. Hello, am I audible?
Yes,
Hello?
Kuldeep ji go on. Prakash ji, aap par aayenge Kuldeep ji ke baad.
Yes.
This is Prakash and Mera.
So, ma'am,
Okay.
is there any particular law about the cyber crime also? Or when, as a head of the institution, if I am not getting the positive response, how can I expect for my students that they will get it?
Okay. Shalu ma'am, you would like to take this too? Then we have two more.
Yeah. Okay. So there are three issues which have come up. One is about the involvement of men, and how should men be sensitized. Now again, this is the major question that we have to engage with men, and how can we do that? Maybe within the classrooms, within the schools and colleges, and as you raised the issue about the law, making law students aware of the social issues. So again, I think we need to work at the broader level where more these kind of discussions should take place at every level, within the schools, within the colleges, in the society. More this kind of investment in terms of knowledge, investment in terms of legal literacy. So we have to work at various levels, starting from sensitizing the children to children or adults or young adults, and also sensitizing the bureaucracy, the police, the judges, and all. And of course, law students and students from sociology or social sciences, they are much better equipped to take up these issues. But only thing is that in the classrooms, if we talk more about the implementation of the law, how law is being operated at the level of on the ground level, or take, like for instance, there are several interns who are coming to to me. So I'm asking them to really go to the court, sit there for a week or 10 days, talk to litigants who are coming over there, try to understand their problems, their perspective, because again, as you rightly said, that in the law colleges, what they are being taught is the case laws. So, but more law is something more than case laws. It is more about the human interactions, how the human interactions are taking place, how the courts are responding to the problems of litigants, what kind of problems litigants are facing in the courts, or with the police, or with other kind of stakeholders. So that is what we have to really work on. We have to really work a lot. And again, I think we have to brainstorm on that. We have to really have more discussions that how to reach out to various these kind of groups. And about the cybercrime problem, what you said is that again there is again problem that how the police is handling that case. So the police said that okay, the case is closed, but then they have not closed that. So again, we have to really see that how police is working in that situation. It may be what kind of their vested interest, it may be corruption, it may be I don't know what kind of thing. So that we have to really see that if at particular level the things are not working, can we go to the level above? So this is the system we have, the hierarchical system, it's there, but then again we have to work in that kind of system, and we have to really find ways that how to make the system work. Now this woman which I was talking about, and I have spoken to this women in courts, they have their own sets of problems. But again, they are dealing with all those problems at their own level. but can we have a kind of some network, something to, the women organizations are helping some of the women, but again, women's organizations are less in number. So how can we reach out to more number of women to address these kind of issues? That is something I think we need to look at. And this group is something I think we all are sensitive about these issues, so we can take up these problems together. This is one suggestion I can make.
All right, Prakash ji, kindly unmute yourself. Okay, Anandita Shankar ji.
Hello, am I audible?
You are audible. Please go ahead.
I'm associated with one local institution, Sakhya, that works in the field of women rights and livelihood development. When we work with college students, especially senior college students, we find that most of these students are just academic oriented. What we did, we talked to some rural development MA and BA in rural development students. And when we enlighten them about these issues related to operation of women and all, especially the tribal women, and then, they found that these tribal women have simply no voice, but these students were given some basics in how you can talk to them and all those things. And, a lot of rural women, these tribal women, they had their cases, they wanted someone to hear and, take some help. So I think if we educate these students, those who are in touch with the grassroots, like rural development, MARD, BA, rural development, then I think, there should be some module. And we tried our best to take help of some lawyers and invited some lawyers to talk on these issues. And the students benefited a lot. And their feedback is that if we are equipped with a small legal module, because in rural development, though it is rural development, the gender issues are not directly part of, especially the operation and the, the legal issues where, they can, file some cases or something. So could you please suggest, is there any module that you have heard of, or any ready module which could be incorporated in their syllabus?
Right. Anandita Shankarji, you have raised your hand. If you can unmute.
Sir, my question has already been answered.
All right, thank you. Okay,
Thank you.
Shalu ma'am, over to you.
Yeah, it's a very good suggestion which you have made about students working within the communities. So we have I think since I have studied social work, MA in social work, so the Delhi University and the Jamia Department of Social Work, they have this field work kind of a thing. Where the student at the graduate level and at the postgraduate level, they are supposed to go to the field twice a week and work with the communities. So that gives you a lot of experience of working with the communities. So I mean, maybe with the with the law schools also, we can have a similar kind of program where where they can be sent to some organizations, local organizations, voluntary organizations, where they can work, for maybe certain part of their, study. They can work in the fields, and they try to work with litigants, with the communities, and with women and other kind of groups. Even with the NGOs can also, collaborate. So maybe we can have these kind of, kind of sessions. And about the legal literacy, yeah, surely I think that should start from school itself. In schools, we can have a legal module in a very, to explain to the students in a very simple way that, okay, beating someone is wrong, or that a mental violence, or, what different kinds of components could be built up with the level of students, the kind of level we are working on. So maybe that could really help to have a kind of, more empowered generation in the coming years. That could be one of the possibility. Yeah, so that thing is very good, that even the students, the law students, could get the opportunity to work in the fields with the in the communities with different groups, including women. So that could be one of the very good things.
Like few more questions have come. Ritika ji.
Yeah, good evening, ma'am. Thank you so much for this informative session. I would just recap the questions that I've written in the question box. Ma'am, there have been several instances of men filing for restitution of conjugal rights to counter complaints made under 498A by stating they have dominion over women, they are the masters of their life, despite them being the perpetrators in the whole act. So how should women counter these false claims? Second question would be, also, how can courts tackle the backlog of domestic violence cases? Because there are so many cases coming each year, every year. So, and the time given to each of these complainants might be years and months. So, and it's not an option for every woman. Like I may be able to access such things, but it may not be viable for someone coming from a lower income background. So, and it can cause a real victimization in the process. So how can courts tackle that? That would be my question.
Thank you. Trizita Gonsalves ji, you would like to ask? Trizita ji?
I have a question. Hello.
Yes.
Hello. Hi, ma'am. Thank you for the very educative session. I have an issue that I live in a very patriarchal family. So I have always strived for gender equality and equal treatment since childhood. But then how do you teach your parents or your family members? I try to emphasize a lot, but still, like over the last 20 years, I haven't been able to do so effectively. So what approach should we take forward while educating our family about these issues, because they are so rigid and it's so difficult to cross those traditional thoughts, etc. So how would you answer that question? Thank you.
So,
yes, ma'am. Shalu, ma'am, please go ahead.
okay, so there one issue is about the restitution of conjugal rights or men filing the counter suits. This is a very regular thing which is happening in the court, that once a woman file a complaint of domestic violence, the husband would file divorce suit or file restitution of conjugal rights, or even the children are being used as a in the like for the custody. They will do all kind of things, even if men are not paying maintenance, but they will use the child for for harassing the woman. So these kind of things are very common in the courts. And if you see in the Western countries, they have a certain kind of laws called as slap suits, strategic law against public participation kind of things, where such a false suits are really being thrown out by the courts at the very first instance. But in India, we never have this kind of thing. But I think we need to have those kind of things which should be there in terms of legal thing. And of course, again, most of the men are filing these suits to prolong the case, to harass the victim, to ensure that she should take the case back, she should withdraw her petition, or she should compromise. So these are the legal tactics which are being used in the courts very often, and all the lawyers, I shouldn't be saying that, but all the lawyers are doing that to either from this side or that side, just to see that this case is being negotiated at some point of time. But it's a wrong practice. But then to really find the way regarding that. Other thing is about the backlog of the cases. Now, again, in the legal system, most of the things which are being this is being also being raised by the judges of the Supreme Court, that the number of courts are less and more and more cases are coming. And so even in high courts and lower courts, if you go to the court one day, and in the family court, if I'm going in Delhi, you will find a case or the list of 40 to 60 cases listed per day. Now, again, it's difficult even for a judge to handle so many cases. But then again, either we should have more family courts, or more kind of people who are being, employed as the judges and all. So maybe I don't know if that could be one kind of strategy, that having more courts and the government investing more resources on legal aid and developing the court infrastructure. That could be one of the things which we can take up. Otherwise, I don't know how to deal with this backlog of cases, because not only the women's cases, but also all other kind of cases, that there is a lot of pendency at various levels. If you talk about lower levels to High Court to Supreme Court, the pendency is huge. So for that, I think the government and the court system, they have to come together and to really, find some way. That could be one thing. But then again, women's organizations, initially, we started with counseling and other kind of things. And, so many work was started during the decades of 80s and 90s when, I could see a lot of work was happening then. But I don't know, we have to take up more and more work, at that level, because I think somehow we have, as a part of women's movement, I feel that we have gone back. We are not making so much of interventions right now. So again, we have to make ourselves more active and make more interventions. That is one thing. The third thing is about educating the family. Now that is the more difficult part, even for me also. My family, I come from a very conservative kind of a family, very typical stereotypical family, and I have to really fight a battle within my family to really see that the rights are being protected, that I shouldn't face violence and all those kind of things. But then, of course, educating a family is something which is more difficult part. There are a lot of emotional issues, a lot of social issues being involved. And say, for instance, in my case, we are two sisters and I was the eldest one. And when I have this problem of domestic violence, I wanted to come back, and my parents said that, no, you won't come back because the younger sister won't be able to get married. So at that point of time, I faced a lot of problems. But then somehow you have to face it, you have to do it. And for that, because we don't have shelter homes, we don't have different kind of ways, options being available in the society. We are being stigmatized if a married daughter comes back. So all these things have to change, and they are changing slowly, but it's very slow pace of change. So maybe we have to do more of work in this area, and we need to have more kind of shelter homes and short stay homes, and helping women who are facing violence, having some kind of policies, because we lack kind of policies, because in terms of helping the woman who is facing violence, how can she get a job, can she learn some skills, can she do something? So what are the programs available for women who are facing violence? That I think we need to work more on that aspect. So that could be one thing which I can, and Professor Patel can add more to it, because I think she has more experience of working with women's movement, so she can add a lot of other things.
Been carrying forward the glorious legacy of the women's movement, as I think all three, Albertina and you are a role model. Albertina also said that every time they face negativity, because she's the one who I think she was the first person in India to come up with a draft law on prevention of sexual harassment at workplace. Is a young law student, and the rampant sexual harassment that used to happen in the state of Goa. So we have learned our articulation and the campaigning from the feminists from Goa. And that how you convert your negative experiences into a positive energy. The same is with me. I come from Patidar's extremely macho masculine community, and at every stage we had to pay the price for whatever freedom that we now which you see that we have attained, but we all had to. But only thing that there was a collectivity, because there was this robust women's movement which stood by us. We all had a collective catharsis, and we also saved ourselves because of the ek aur ek 11. There is a strength in number. I think all three presentations were extremely illuminating and insightful. All three of them are practically rooted in the subjects which they spoke about. And I think Albertina's presentation and a vivid description of all the processes that person like Suman Devi Bajaj or Bhavri Devi had to undergo to get where they are. And even after this very, very bitter and painful and heartbreaking battle, they still are fighting. Bhavri Devi is still very active in People's Union for Civil Liberties. She attends meetings. She energizes, gives energy to the younger generation of women. That's very important. When it comes to abortion, the scenario is extremely bleak. There are still countries in Latin America, Africa, even Asia and Philippines. When I went to Philippines, the women, the way they were describing their painful experiences of delivering 7 children, 8 children, 9 children in the midst of poverty. The children after born, they are begging, they are given, but traffickers are taking them away. You know, all these recent scandals about trafficking and the 300 children dying, 400 children dying. They are from all these from Asian countries where women are not even given any kind of family planning measure, or the religion is strictly against abortion. And when women are caught, even in this dangerous abortion, they are put behind the bar. So I think it's a very long battle, and the way even what is happening in America also currently, that the different states are following different methods of putting restrictions on abortion. So I think it's a women's movement's position, abortion as a backup service on demand by women and safe and affordable abortion is a women's right. And I think Dr. Chisani it has been always a spokesperson, and the same thing coming from a man's, this thing is the medical fraternity finds it more convincing than we women screaming. So that is also, so gender in medical education endeavor has taken it up. The last one, Dr. Advocate Shalu Nigam's presentation, brilliant and extremely exhaustive. And what I want to add is only one thing, that the PAVDA Act, Protection of Women from Domestic Violence Act, the budget that is involved, because this act has a very clear-cut role for 5 service providers: hospitals, protection officer, counselor, shelter home, and even about the children's, if woman is accompanied by children, and for which you need a massive budget. We as gender economists have been fighting for a more and more allocation of budget so that you can allocate funds. Functions can be supported by funds and functionaries. And so many states have not even done. Andhra has a good record, but one-stop crisis center, if you see the recent NFHS data, the Karnataka shows the highest number of cases of domestic violence because they don't have any one-stop crisis centers. So the states where you have a support system in terms of, as Dr. Shalu Nigam told us, that shelter homes, short stay homes, counseling facilities, because when you face so much of violence, you also have a suicidal tendency. You know that nobody is with you. But if there is someone to hold your hand, and that has been the strength of women's movement, we can boast of only one thing, that anybody who has come in touch with a feminist or a women's organization has never strayed. She has gone ahead educationally, in terms of finance, in terms of this thing. One thing that women's movement does is that just hand holding and solidarity, and the women rebuild their life, and they also rebuild lives of so many women who come in their life too. So that is one. The most disturbing thing which we saw was yesterday's paper, where NCRB data, National Crime Records Bureau's data, which shows that 50% of all suicides committed by women are by housewives. That means spousal violence, domestic violence is an acute issue, and whatever the misogyny, which and the examples of misogyny that Dr. Shalu Nigam gave us, it's extremely heartbreaking that the criminal justice system is coming up with such a regressive attitude, police as well as the courts. And I think that is major reason is that gender sensitization programs have stopped. During 80s and 90s, we remember that there used to be intensive gender sensitization program, which young police officers, the new recruits, police officers, judges, and those who are managing the course had to undergo. Now everything is gone. And that generation of lawyers and judges as well as police officers have retired. The new generation has completely, it's a blank slate. They have not been, and they continue with the same misogyny and stereotypes which the society has. So I think we have a long way to go. I would like to end with the 3 interventions made by Madam Nina Joseph. I fully agree with what you say. The way gender sensitization programs are supported by the state government of Kerala It's a very, very important thing, and all states need to emulate that example. Even in terms of the fund allocation, Kerala's fund allocation to prevent domestic violence is high, though Kerala is also facing a major challenge of consumerist onslaught, which is for the first time we are hearing such a high number of dowry murders in Kerala, which we had not, because Kerala was always first in human development and gender development index and all. But the violence against women and gender-based violence is a major challenge even women's movement in Kerala is trying to grapple with. But I think today's day was extremely rewarding, and I commend all three resource persons for their erudite, well documented and well argued presentations in this monsoon course online legal awareness program.
Thank you so much, ma'am, for concluding today's session. Very lovely words there. I must say that all of our participants are very engaging today, and they even shared personal anecdotes. Thank you for sharing all of that. Those, more power to all of you. As we come to the end of day 2 of the 3-day immersive online legal awareness and certificate training program on women's rights, laws, and policies in India. This training course is organized by IMPRI, Gender Impact Study Center, GISC. I, Tripta Behra, researcher, IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, Gender Impact Study Center, GISC. We are grateful to our experts for the day 2 of this. Advocate Dr. Albertina Almeida, Dr. Amar J. Sani, Advocate Dr. Shalu Nigam, and our chair, Professor Vibhuti Patel. We thank all of our participants for their patience. We have extended the time a lot today, so thank you for sticking throughout. All of them have raised pertinent questions and actively participated in today's deliberation. We welcome you tomorrow, September 3, for our day 3 sessions of this training course by distinguished experts, Ms. Urvashi Prasad, Professor Bijay Lakshmi Nanda, and Dr. Nivedita P. Haran. We are grateful if you are watching us later on YouTube or listening to us on various podcasts or reading our publications. We hope you continue to join in the future to IMPRI Web Policy Talk and Web Policy Learning. Wishing you all a very good evening. Thank you and good night.
Thank you.
Thank you so much.